for pronouncement of judgment. I didn't produce the list.
It is trite law that mere empanelment in a select list will not give an indefeasible right to be appointed. Admittedly, so far as the district of Hailakandi is concerned, the number of vacancies were 3 and the position of the petitioner was 5th. Since this resolution was taken by the selection committee that further vacancies will be filled up, the incumbent above the petitioner against serial number was given appointment within the validity of the selected, which was 1 year. However, it is not the case of the petitioner that any person below the petitioner in the select list has been given an appointment, and therefore the regularization of an incumbent who was appointed in the year 2001 cannot be a reason to hold the petitioner to be entitled for appointment. There is another aspect of the which this court has noticed. As on today, the petitioner is aged about 54 years and much beyond the entry-level age for government service. The court has also noticed that though the recruitment process was of the year 2005, the attempt by the petitioner to extract information under the RTI was only in the year 2016, which is more than a decade. Such selection on the part of the petitioner to pursue his right in the court of equity would be a factor which should be against the petitioner, but petitioner is dismissed.
Particular compelling situation I pay for before your lordship for listing of a petition, the restriction of 2018. It went to the division bench. Division bench.
18 matter will have it.
Yes.
Wednesday next.
Next week, my lord, any date.
Wednesday next.
But deeply obliged,
Yes.
Despite being a very old matter, lordship, I am constrained to mention item number 1 and 2 of the tail list, lordship.
Yes, why have you mentioned
Lordship,
these matters?
there is a subsequent development, lordship. Subsequently, the petitioner was dismissed from service, lordship, followed by departmental proceeding, lordship, and which is come up before your lordship on Tuesday, lordship, which is under challenge, lordship. Lordship, if this, I will succeed in this matter, lordship, then it will survive, lordship. Lordship may fix this matter after 2 weeks, lordship.
12 matters. What are the cause of action here?
Lordship, regarding promotion in this promotion, lordship.
He has already been dismissed.
Yes, lordship. And which is under challenge, lordship. Lordship may fix this matter on Tuesday, lordship, the dismissal matter, lordship.
Both the matters.
Yes, sir.
Promotion.
Yes.
It is submitted that certain developments are there for which adjournment has been sought for. Para. However, considering that the matters are of the year 2012, comma, short adjournment is granted, directing listing of this matter after a week.
Deeply obliged.
Two matters.
With the consent of others.
Okay.
The consent of others that I paid my item for 24, my lord. In this case, my lord, the respondent bank, my lord, has been amalgamated to Assam Government Vikas Bank.
Yes.
So, my lord, I have to impute the Assam Government Vikas Bank, my lord, so I have to file an ISI.
Is it required? 24. 17 matters. Have you informed the other side?
Yes.
Sri G. Alam, learned counsel for the petitioner, submits that due to subsequent development, comma, implement application is required to be filed. Para, he accordingly prays for and is granted 2 weeks time to file such implement application. Item this 2024. Yes.
May I pray before lordship? I pray before lordship for listing a matter 2018 matter, hearing matter. This is still from
18, okay. 18.
Any date?
Next Friday.
Must.
Yes, Mr. Shah.
Listing of a matter, my lord, of 2022, promotional matter, my lord. Earlier on several occasions, PWD.
When was it last listed?
My lord, it was listed on May.
What was the order?
Space for time by the PWD.
Okay, Friday next.
Next Friday.
Yes.
Obliged.
May I please? Notify the two mentions for lordship entirely relating to suspension.
Suspension. When was it last listed?
Your Lordship, during the pendency of departmental.
When was it last listed?
Last Lordship 14/6/2020.
What happened then? What happened on 14/6?
14/6, status report for us.
What are your grounds of challenge? Periodic
During
review.
the pendency of departmental proceeding, I got the permission from my sir.
So how do you reinstate the suspension? What is the urgency?
So Lordship, only because of that, Lordship, my pensionary benefit has been.
Nothing to do with
taken
your
up.
suspension. Suspension has become infractious now. You are out of service by superannuation. Not a matter of out of turn listing.
But
Sorry.
Lordship, one clarification is to be required, Lord. Yes, because Lordship, the department has not initiated my pensionary proposal as because Lordship case has been pending before this Honorable High Court, Lord. In the meantime, Lordship, no speaking order has been.
That is a
passed on
different
basis
cause of
the
action.
suspension.
You challenge it. We'll look into it.
Sir, Lordship,
Non-payment
what
of
basis I
pension.
challenge, Lord?
Non-payment of pension. Are we here to advise you, Mr. Counsel?
Yes, definitely.
Why are you asking the court? What is the basis? We are not here to advise you what to do, what not to do. Don't ask questions to the court. If you do not adopt the right procedure, how can we help? Not a case of out of turn
I am
listing.
challenging suspension.
Suspension, you are superannuated. Where is the urgency? Tell us. Can you be reinstated? No.
No, Lord.
If you are aggrieved by a pensionary aspect, challenge it. Yes.
Lordship,
May I
another
please-
one, Lordship, for pensionary benefit. Another,
Filed when?
Lordship, 2023 case
Okay. Pension next Wednesday.
of life.
May I please, Your Lordship, I beg to mention for listing the W50 matter for admission.
Matter of which year?
2023.
23. 23 matter out of turn list. What is the subject matter?
Lordship, he has not been paid the adequate salary and retirement benefits.
Retirement benefits. Adequate. If something has been paid to you, you are asking for some other skill, not a matter for out of turn. Sorry. Next.
Please, Your Lordship. Lordship, I beg to mention an IA, Lordship, in WBC 2697. Lordship, the urgency is that in the last order, which was on 24/5 of this year, there was an order of this Honorable Court where an post was to be kept vacant if there exists any. Lordship, in the recent developments, the post has become vacant. Lordship, therefore, we have filed this IA.
You have filed fresh?
Yes,
Okay, we'll have the IA on Wednesday next.
Lordship, if it can be on
When did
Friday.
you file?
Lordship, 6th of this month.
Numbered?
Yes, Lordship, filing number is
Okay, Wednesday next.
Lordship, if it can be on Friday.
Friday next, okay.
Oblige.
Please, Your Lordship, I beg to mention item number 28.
28, yes.
Lordship, my senior is not well checked. So I will.
Okay. Who is the senior?
Dibor.
Dibor Gohai. Okay, yes, government? Item 28. It is submitted that the learned counsel for the petitioner is unwell. List after a week? 1 week, yes. Yes, madam.
I beg to receive of a petition.
Read petition of which year?
Sir, 2020.
23. What is the subject matter?
The compensation family.
Family pension. Okay, Friday next. Where is your mention memo? Item 3 and 4.
Mr. Armozo has conducting the Lordship. Can it be taken after some time, Lordship? He's on Lake Sport number 2, Lord. Sometime may be given, Lordship.
14 matter, but ask him to come after a while.
Lord, at 2, my lord. I have one another matter in court of parole.
After a while, let him come.
Yes.
If you're not there, we'll accommodate.
He will take in some time. Court of-
We'll wait for some time. We have some other matter.
Lordship.
Yes, Mr. Bhumi.
Yeah, please, Your Lordship. The other side is not here. Here, the petitioner has challenged The punishment
State
of.
Bank, State Bank.
Okay.
State Bank has counsel.
Yes, Mr. L. Talukdar was appearing and
Now
he was,
presently, I think there are different separate counsels. Mr. M. Sharma normally appears.
now on the last occasion, Mr. L. Talukdar appeared
Okay.
and he was directed to produce the record. The other day I
25
met him at the bar. I asked him-
25/7.
I asked him whether the records have come. He said yes. And he'll be producing it.
Name has been reflected, yes. What is the matter?
Matter is, I am aggrieved by the punishment of
Disciplinary proceeding.
disciplinary proceeding.
Okay, records will be necessary.
Yes,
Can you contact Mr. Taludar? or
I'll try
any-
to contact
Okay.
him.
We'll try to have this today itself, 15 matters.
Yes.
Lordship, in this matter, on last occasion, Lordship has called for the record, Lordship. As per my instruction, Lordship, yesterday evening, they have sent the record, but so this will be taken up of any day next.
What is the matter about, madam?
It was, major punishment was
Okay,
subjected.
disciplinary proceeding.
Yes.
Records haven't transmitted to you. No, you have not
Yes, just.
gone through. Oh,
no,
okay, you go through the record. We'll have it when? Tuesday next?
no.
Matter of which year? 2020. Okay, but we'll have it on Thursday next or after 1 week. Okay. Heard Miss S. Goswami, learned counsel for the petitioner. Para. Miss M. Bhattacharya, learned so submits that the records have just been, records of the departmental proceeding have just been received. Full stop. See, accordingly, prays for some time to go through the same. Para. List after a week?
Sure.
Okay. Seven.
May I plead your lordship? Lordship, on the last occasion, lordship, the report was submitted by the
Affidavit
respondent.
filed. PNRD.
Senior is on legs on code 17.
Who's your code, senior?
That's that.
But have you filed the affidavit? Last time you had
Yes, sir.
24/7, you had filed affidavit, not filed.
No, fine, lordship. And 2 times are there taken time, lord.
No, last occasion we had recorded that the instructions have been received.
Yes, sir.
Yes, ask your senior how, when can you file the affidavit? We may grant some time. Ask your senior, come back.
Yes. Okay.
Affidavit has not been filed. How much time? Is it prepared or what is the stage of filing of the affidavit?
Yes. Like,
Happy Lordship. The same matter has been conducted by R. Mozunda. He is coming. Lordship. Can it be after some time, Lordship?
After a while.
Very well, Lordship. Master.
Item number 11.
His office way matter just after the office way
Who, Mr. Chaudhary will be
Yes.
appearing.
fully prepared with the matter.
You're adjourning all matters. How do you do?
After surface, just after he is the
Till now, all the matters have been adjourned for some time. Okay, after a while. Item 12.
May I please?
Forest Department.
Forest Department, madam.
If the petitioner's counsel is there, respondent counsel is not there. If the respondent counsel is there, petitioner counsel is not there. Forest Department. Name shown or not? Shown. Mr. Chauhan, what is the matter, Mr. Chauhan?
My lord, he has been working under TF2, my lord, Karim with my lord.
Yes.
And as my lord, casual labor, my lord.
Hmm.
But my lord, continuous, my lord, service there. And my lord, since 1993. But my lord, this department not believe that he has been working since 1993. However, they admit that yes, it is found that he has been working since 1997. And my lord, proof of payment is also there, my lord.
Now, what is your relief now?
My lord, my case, my lord, is squarely covered by my lord, the case of the Upendas, my lord. I have employed the judgment also, my lord. Because my lord, earlier actually we approached this honorable court, my lord. Honorable court, my lord, says to consider the case of the petitioner, but my lord, they my lord, not consider.
Yes.
They have filed recently they filed an additional affidavit, your lordship, whereby the TFO has already communicated to Principal Chief Conservator of Forest, stating that I have the honor to enclose here with a list of additional 2 numbers of casual worker as per prescribed pro forma prior to AF RPM period, post AF RPM period, but in this forest division for a kind information necessary action, lord. So the matter is now before the PCM, lord. Let the matter reconsider afresh in his lord, but the PCM, lord.
Now, if he is entitled to the benefits of Upendas,
Yes, lord.
we can dispose of this matter. Why do
Yes.
you
And
keep
my
this
lord,
matter pending?
long pending matter, my lord.
You have also filed your affidavit, isn't it?
Yes.
You have not filed affidavit.
No,
It is
we have not
not
filed,
filed, my lord, but their documents shows that, my lord, it is admitting that they are 1997.
Have you received the instructions?
We have received the instruction, lord.
What does it say? It is before the PCCF now.
It's a people PCF, lord.
Then you finalize it.
Yes, lord. It is finalized.
You verify and finalize it.
Exactly.
Mr. Chauhan, no point having this pending.
Yes, lord.
Okay.
Okay.
Yeah, please, Your Honor. So far as entitlement to the petitioner is concerned, that will be left open, my lord. So apparently, my lord, it doesn't appear, my lord, that we come to the exam, my lord, in Delta.
Why?
Village bench decision, lord, to the time.
My lord, page 64 kindly be, my lord, Peru.
But are you working since 2001
Yes, my lord, yes.
without pay?
Without pay, my lord.
2001.
Yes, my lord. My lord, kindly see the page 64, it is there, my lord, pay, my lord, proof of their, my lord, working, and this is the
64.
middle, 64 middle.
Yes.
My lord, Sanjay Das, my lord. One
No,
Nihar.
this is of 97.
Yes.
Yes,
But after 2001, Till 2024, you are
Well,
working.
yes, my lord, working, my lord. Earlier also I have paid the honorable court, my lord.
You are working for 24 years without pay.
My lord.
Is it believable?
My lord, it is going so, my lord.
Is it believable?
It is going
24
so,
years you work without pay?
Yes, my lord.
How are you surviving?
My lord, and family members, my lord, is also were burden, my lord.
Now, how are you surviving?
Yeah, that is the question, my lord.
Now, 24 years you are working, you claim to have been working without pay. Is it believable?
My lord, with hope, my lord, that my case will be.
With hope. Can you
No.
survive for one week without payment, without food?
That's right, my lord. But now
You are surviving for 24 years.
my number of occasion right from beginning, my lord, approaching to DFO, the PCCF, my lord.
Now, is he working after 2001?
That's a record we are not being able to trace, Your Lordship, whether he's working or not.
Perhaps it's for that, whether the authorities have reported the finding, my lord, that.
Where have you
are not
stated, Mr.
available.
Chauhan, that you are working?
We will have
Where is
to
the document?
pay a prima facie case.
My last document court my lord wanted to know whether I am working or not. My
Yes.
lord, in the affidavit, I have employed the document, 5 my lord on 9/4/24.
Page
My affidavit page 90, my lord.
90.
90,
Yes.
section 26.
Correct document.
Yes, why don't you take instruction, Mr. Gogoi, on this? There is a document of 24,
Yes, sir.
5/3/2024, issued by the DFO.
Yes, that's.
He must have given it on the basis of some records. The enclosure to that, page 91. Have you seen this?
Yes, Your Lordship. Still working, date of 93.
If he is working, there is no question why he should not get the benefit of Upendas. Take instructions on this.
Very well, Lord.
Matter of which year? 23, you take instructions. Part 3, as shown, learned counsel for the petitioner. Full stop. The petitioner has filed an additional affidavit on 9/4/2024, with which he has enclosed a communication dated 5/3/2024 of the DFO, Karimganj Division, to substantiate his claim that he is in continuous service. Full stop. Let specific instructions be taken by Sri R. Gogoi, Learned Standing Counsel, Forest Department, in this regard. List on September 11th.
Very well, Lord.
এখন করে দিলে হবে। বেরিয়ে আইছে নি? মিস্টার চৌধুরী, your matter.
Wait, please, Your Lordship.
Other side,
Yes, Your Lordship.
who's there? What is the matter?
Amala, the matter, these two petitioners, my lord, they are claiming promotion from junior engineer to assistant engineer on the basis of the, my lord, AMIC certificate, which is equivalent to BED. Amala, there was a selection and the selection committee recommended the names of the petitioners for promotion. However, my lord, that did not take effect. And eventually there was another repetition earlier. And
You are holding the post of presently?
junior engineer
Where?
in the water resource department. Two petitioners, my.
Yes. Now you claim promotion to the post of?
Assistant engineer.
Assistant engineer. Okay.
The petitioners, my lord, they obtained AMICE,
AMIC.
Associate Member Certificate, my lord, Associate Member of Institute of Civil Engineers, India, Ludhiana, Punjab.
Associate member.
Associate Member of Institution of Civil Engineers
Of institution.
of Civil Engineers, bracket India,
Of civil engineers.
from my lord, Ludhiana, Punjab.
Okay.
Now, my lord,
You
this,
obtained your diploma.
yes, my lord, this is a certificate. This is a
Certificate.
certificate, in fact, my lord, and that has been, my lord, treated as equivalent to BE degree by the, my lord, All India Council of Technical Education and other authorities, Ministry of Human Resources also, my lord. I'll have to show your lordship that, my lord, this is equivalent.
Yes.
So what happened, my lord? There was a selection committee meeting, my lord, board. And if your lordship kindly comes to page 48, before that, your lordship may note one date, my lord, that will be a very crucial date. That is 31/5/2013.
What is this?
31/5/2013 is the date, my lord. My lord, the institutes, my lord, where the petitioners and others are taking different professional courses. Those who have taken admission prior to that date, those will only be valid, and subsequently it is not. I'll show your lordship that also, my lord. 31/5/2013 is the crucial date. Now, your lordship may kindly come to page 48.
Yes.
This is the minutes of the selection board's meeting that was held in, my lord, 2017. There, my lord, the rule has been quoted under which the junior engineers having B degree, they are entitled to be considered for promotion as assistant engineer. Your lordship may come to, my lord, the second paragraph. As per Rule 11.5 of the Assam Engineering Part Control Department Service Rules 1981, a junior engineer may be promoted to the post of assistant engineer subject to suitability. A subordinate engineer grade 1, now junior engineer, on his acquiring the academic qualification as prescribed for direct recruitment of assistant engineer, shall be promoted as assistant engineer in consultation with the commission as provided in Rule 14 against next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer. The cadre strength of assistant engineer civil under Water Resource Department is 216, out of which 152 numbers, 70% are to be filled up by direct recruitment. The vacancy position means the direct recruitment in the cadre of assistant engineer Water Resource Department during the year 2017 is 83. The Water Resource Department has sent proposal to the APSC for initiating the process of recruitment in respect of 65 posts out of 83 of assistant engineer civil. As such, 18 numbers of posts of assistant engineer civil means for direct recruitment, recruitees are to be considered to be filled up. Now, my lord, there are 12 number of junior engineers.
The water assistant proposal for out of 83.
The names of the petitioners figure at serial number 6 and 7.
Now, what is this meaning? The Water Resource Department has sent proposal to the APSC for initiating the proposal for recruitment in respect of 65 numbers.
65 numbers of posts out of the 83 numbers of assistant engineers. As such, 18 number of posts or assistant engineer means for direct recruitment are to be considered for filled up.
Why 18 numbers?
In fact, my lord,
I
this
think
should
these
be
18 numbers should be for promotion.
yes, ma'am. In fact, this
65 are for direct recruitment from fresh graduates.
Yes, ma'am.
And from in-house junior engineers who acquire AE,
Yes.
I mean the BE degree or equivalent, they would be promoted and they will be treated as direct recruits.
Yes.
I think
Yes,
that
my
is the meaning.
But then this sentence is perhaps wrong, but the meaning your lordship will understand, my lord. This 18 posts are for the, my lord,
Promotees.
promotees. That is the, my lord,
Yes.
understood,
Yes.
the mistake is understood, my. And my lord, 12 number of the candidates were considered. The names of the petitioners figure at serial number 6 and 7. Srimati Rohini Fangchupi and Sri Hori Deka. Now,
Now, 12 numbers. Junior engineers applied for promotion service. Your name is there.
6 and 7, my lord.
Oh, these are the names and seniority.
Yes.
Okay.
Now, my lord, this the paragraph, third paragraph, the details that may be, my lord, relevant, because
Petition
otherwise,
number
my
one,
lord, I have
petition
to
number 1, serial 6.
6,
And petition two petitioners.
2 petitions.
Rohini is 1
Rohini Fangchupi
and
and it says, my lord, SCH and Hori Deka,
P2.
P2.
Okay.
Now, your lordship may kindly read this details because that may be relevant. Otherwise, my lord, I have to take your lordship to many papers.
Okay.
Many things have been noted, my lord.
Yes.
Sri Kulenda, so and so, your lordship may skip.
Hmm.
Then your lordship, my lord, come to about line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 line, my lord.
Hmm.
The name of Horidaka appears, my lord.
Yes.
Sri Horidaka has got NOC
Yes.
from Water Resource Department for the study course and acquired academic qualification through self-study mode. Then Sri Kapondaka, your lordship may skip. Then
Hmm.
Srimati Jumi Kolita, Srimati Rohini Pangchupi, Srimati so-and-so had got admission into the degree course before joining the department as junior engineer. My lord, why I am stressing this, my lord? There are 2 affidavits filed by the department. In the first affidavit, my lord, they had taken the ground of ratio in a case of the Honorable Supreme Court. That is, my lord, Odisha lift irrigation case. So, my lord, they said because of that, my lord, we are not entitled to get promotion. That was the, my lord, first affidavit. And in the second affidavit that was filed only the other day, they had taken a fresh ground that you have not obtained NOC from the department.
But Horidoka had obtained an NOC.
Horidaka has obtained, my lord, that is at page 42, your lordship. I'll take your lordship.
49 also the minutes reflects that he has got an NOC. The minutes itself at page 49.
Records, my lord. So contrary to these minutes, my lord, they have taken stand in the affidavit. That is why, my lord, this Majorate Pangchupi, my lord, she had taken admission much prior to the my lord appointment and selection, and that has been recorded. He got admission into the degree course before joining the department. Therefore, my lord, there is no question of obtaining any NOC.
Yes.
The next para, all degrees acquired by the incumbents concerned, that is A and B of AMIC in the civil engineering from the Institute of Civil Engineers, Ludhiana, Punjab.
Tell us one thing, Mr. Chaudhary. Both the petitioners, while they were inducted as junior engineers, they were holding what qualification? Diploma holder?
They were diploma.
From?
From, my lord, India, ITI, Indian
Okay.
Technical.
And while in Horidaka, while in service, he got the that certificate from AMIC.
Yes, my lord. After
And
NOC.
as so far as the petition about 1 is concerned, she had got admission before, even prior to induction in her service.
Yes, my lord.
Okay.
She was appointed in 2010. She obtained the, my lord, certificate in 2010. So she was admitted much prior to the my lord appointment in the department. Now, this has the equivalence of the degree has also been discussed in this minutes, my lord. All degrees acquired by the incumbents concerned from the AMIC, from the Institution of Civil Engineers, Ludhiana, Punjab, and to Bachelor of Technology Civil Engineering from Techno Global University, Shillong, Meghalaya, so other institutes have been mentioned, are equivalent to degree course prescribed for a direct recruitment of assistant engineer civil as approved by AICTE, All India Council of Technical Education. The selection board observed some earlier promotion made by Water Resource Department in respect of some officers who got academic qualification from the above mentioned colleges and institutions. So, my lord, this is not the first time that, my lord, they are promoting, or, my lord, this petitioner. It was happening in the department. Then, my lord, the department, there were no department proceeding. Eventually, my lord, selection list is at, my lord, page 5050. Name of the petitioner number 2, 1 appears as 6, Haritaka 7.
Page
they are
60, 50.
50. After threadbare discussion, the selection board decided to recommend the following officers for promotion to the post of Assistant Engineer Civil as per Rule 11.5 of the Assam Engineering Clerk Control Department Service Rules 1981 and advised to get approval of the Assam Public Service Commission before promoting them. Then, my lord, your lordship may
Yes, please.
now, my lord, the respondent number 5, the Director of Technical Education, issued some clarifications that may be relevant, my lord. May I take your lordship to page 204?
Now, what is the difficulty after recommendation? You have been recommended.
I've been recommended, but that has not been carried out till date, my friend.
Oh, no, nothing has been done thereafter.
Nothing.
Yes.
Lordship. Lordship, 90
I will come back to you, Mr. Chaudhary, but we want to know the reasons why.
Lordship may kindly peruse our affidavit, Lordship, which we have filed, Lordship, in paragraph 7 of our affidavit,
Page
page 215.
just a minute. Yes.
May I read, Lordship? That with regards to the statement made in paragraph 8 of the writ petition, the deponent begs to state that the advertisement made in the said paragraph is not correct. In view of the objections raised by the Federation of Engineering Service Association Assam, and in view of the Honorable Supreme Court of India judgment and order dated 3/11/17,
You are reading which paragraph?
paragraph 7, Lordship, page 215.
216. Paragraph 7.
16, yes, paragraph 7,
7.
Lordship.
Oh, 7. Okay, okay. 215. Last part.
Yes, Lordship. In Honorable Supreme Court of India judgment and order dated 3/11/17 in Odisha Leaf Corporation Limited versus Ravi Shankar Patro and others, reported in 2018 1 SST 468, wherein the degrees in engineering awarded by the concerned deemed to be universities to distance education mode were recalled and treated to be cancelled, and as the promotions of the petitioners concerned were not given effect. Paragraph 59 of the judgment is quoted below. We therefore declare that in respect of students admitted after the academic sessions of 2001 to 2005, the degrees in engineering awarded by the deemed to be universities concerned to distance education mode shall stand recalled and treated as cancelled. Any benefit which a candidate has secured as a result of such degrees in engineering in the nature of promotion or advancement in career shall also stand recalled. However, if any monetary benefit was derived by such candidate, that monetary benefit or advantage will not be recovered by the department or employers concerned. We further direct that the entire amount paid by such students to the deemed to be universities concerned towards tuition fees and all other expenditures for such courses to distance education learning shall be returned by the deemed to be universities concerned to the respective students. As mentioned in paragraph 34 of the judgment and order dated 24/1/2020 in WPC 889/2018, Rohini Pangkapi and others versus the state of Assam and others, there are some requirements for a candidate to become eligible for the associate membership grade of AMICE with his or her name. In point number 4 and 5 of the aforesaid requirements are quoted below. Point number 4. The candidate has passed section A and section B examination of the institution and has an experience of 3 years working in an organization engaged in promoting civil architectural engineering profession. 5. The candidate has acquired practical experience of 3 years in a manner satisfactory to the institution in promotion, planning, design, construction, maintenance, or management of such workers as comprised within profession of a civil architectural engineering or in civil architectural engineering research or teaching of engineering in a course leading to the qualification approved by the institution. The practical training for association membership will be carried out in AICTE approved engineering college, and the practical assessment will be conducted by the concerned engineering colleges wherever the candidate is undergoing practical training. The project report for association membership is to be submitted to the principal or head of the Department of Civil Engineering Architectural Engineering of AICTE approved engineering college. On meeting the requirement as above, a candidate becomes eligible for associate membership grade of the AMICE and is entitled to write AMICE 1 with his or her name. Accordingly, white letter number so petitioners were requested to submit the details of practical experience of 3 years in a manner satisfactory to the institution in promotion, planning, design, construction, maintenance, or management of such work as are comprised within the profession of civil engineering, duly certified by the head of the department or principal of the institutions wherein the practical training has undertaken. They were also requested to submit the details of duration of the aforementioned practical training and the faculty of the institutions under which the training has been undertaken. In reply, the petitioners have intimated the Water Resource Department that they have done the practical training through practical experience from the institute office as mentioned against their name in the following table. The table is given there. From the above, it is found that none of the above mentioned institute, organization, office is an AICTE approved engineering college. As such, they were once again requested to furnish the certificate of 3 years practical training received from the AICTE approved engineering college. Department has not received satisfactory reply in this regard. Furthermore, it may be out of the context to mention that according to the petitioners in WPC
It may not be. It may not be out of context. Not it may be, it may not be.
may not. I'm sorry.
You missed not.
Yes, sir.
It may not be out of.
It may not be out of context to mention that according to the petitioners in WPC 889/2018, as indicated at paragraph 45 of the judgment and order in question, they did not undergo the course and training in Ludhiana, where the state institution of civil engineers is located. They underwent the course and training in Kamrup Educational Trust, which is an institutional member of the aforesaid institution of civil engineers Ludhiana, and it has also been submitted by them before the Honorable High Court that as an institutional member, the State Kamrup Educational Trust was authorized to offer practical courses which the petitioners did not undertake. But the petitioners in the present writ petition did not submit any certificate of practical course issued by the Kamrup Educational Trust. This department has repeatedly made queries to AICTE in the matter of whether educational certificates awarded by the Institute of Civil Engineers India are valid or not, whether the courses undertaken by the petitioner in the state institute are distance mode or not, but no specific reply has been received from the AICTE's end. Meanwhile, the Deputy Director, Department of Higher Education under the Ministry of Education, Government of India in the matter whether education certificates awarded by the Institute of Civil Engineers India are valid or not, and whether the courses undertaken by the petitioners in the state institute are of distance mode or not, has stated the matters is under sub judice by their letter number 23/9/2022, which we have annexed the letter.
This is of 2022.
Lordship.
Thereafter, what has happened?
Till that we have not received any specific, although AICTE has filed an affidavit. They have stated that practical courses means the courses offered by the institute were valid till 2013. That already we have stated that they are valid till 2013. But beyond that, nothing has been
When
stated.
did you
And
complete
whether
your,
the degrees are
when did they complete the certificate? Certificates issued when, Mr. Chaudhary?
petition number 1, 2010, petition number 2, 2012.
Prior to 2013.
It is the
In
Lordship-
fact, my lord, it's not the, my lord, the certificate or degree obtained. It is the, my lord, date of enrollment. So persons enrolled before 2013, 31/5/2013, even if they pass subsequently, they will also be my lord.
Lordship, in paragraph 33, page 130 of the
One-
130,
130.
130.
Just a minute, please.
My lord, one fact I have, my lord, wrongly stated. Petition number 2 obtained in, my lord, 2014.
Okay.
2014, but enrolled, my lord, prior to that. Prior to, my lord, 31/5/2013.
We will need that particular,
Yes,
Uh,
I'll show the document, my. I'll
yes,
show the document.
that it is the date of enrollment which is
Yes.
crucial.
May I give the, my lord, page number?
Yes, please.
The petition number 1 passed in 2010, my lord, that your lordship will get at page 43. This is the certificate. The examination held in winter 2010.
Okay. 43 and P2?
And P2 obtained in 2014, page 44. Held in summer 2014. But my lord, the date of enrollment, your lordship will find, my lord, because the course is, my lord, 2 years. And I have made the averment that enrolled on 20th of February 2011. 3 years or 2 years? 2 years.
And where do you get that the date of enrollment is crucial?
Enrollment, my lord, I have given the averment only, my lord.
No, that the date of enrollment is crucial.
Yes, my lord. The 20th of February 2011, that I have stated.
No, not your statement.
My lord.
That it is the date of enrollment which has to be taken into consideration. Not the date of passing.
Oh, my
You said that 2013, up till 2013 is valid.
Yes.
So far it relates to date of enrollment.
Yes, my lord.
From where do you get?
That your lordship will get at page 96.
96.
96. That is a public notice issued by the All India Council of Technical Education.
Degree obtained till 2031/5/2013 is valid.
No. That rule. Second clear. This is a public notice for professional bodies and institutes imparting technical education. Second paragraph. Accordingly, the council, in its 52nd emergent meeting held on August 3, 2017, decided to recognize equivalence for all purposes, including higher education and employment, to technical courses conducted by various.
We have read this. We have read.
Right.
Thus, for all students who were enrolled.
Enrollment. The exactly meant of the same words have been used in the affidavit of the AIC. And your lordship may also like to know the equivalence, my lord. Regarding equivalence, my lord, there are
Now we
two-
have to just examine whether the observations of the Honorable Supreme Court in Odisha lift
Yes, I'll tell you.
would be applicable vis-a-vis the certificate obtained by you from Ludhiana.
Yes. On that matter,
That
I'll
is the
explain.
only,
Regarding the,
we'll come back.
Fine.
regarding the no objection certificate,
Yes.
regarding the no objection certificate, which was issued to the petitioner number 2 by the department, annexed in page 42,
Just a minute, please.
page 40.
Just a minute, just a minute. Now, petition number 1 got no objection.
Petitioner number 1 has got, history has not obtained no objection from the department.
No,
Regarding petitioner number 2,
You come to page 49. 49, we have just noted. What is the name of the petition number? Okay, okay. Haridaka is the petition number 2.
2,
Okay, sorry.
and in page 42, the NOC which
Just a minute. Haridaka is it? Petition number 1 is, oh, this is petition number 2.
petitioner number 1 is Rohini Pang.
Okay. Rohini, 6. She did not get no objection.
No, he has not obtained
Say number
objection
6. So
from the
petition
department.
she was admitted prior to the appointment. She was
Yes,
appointed.
yes, pilot. Petition number passed in 2010. That is at page 43, and she joined service in 2010. So there is no question of obtaining any NOC from the department.
Regarding petitioner number 2, Lordship may kindly peruse page 42, Lordship.
42.
Yes, Lord.
Yes.
The last portion of the NOC, Lordship.
Hmm.
With reference to the above, I am directed to say that the department has no objection to your prosecution of degree course of associate member of the Institution of Civil Engineers, AMIC, under the Institution of Civil Engineers, India,
Yes.
Punjab, on distance mode,
Yes.
subject to no impede in day-to-day departmental and official obligation vested upon you. It is specifically stated that it is for distance mode
Yes.
in the NOC, but they have claimed that they have done the regular, they have obtained their degree in regular course of obtaining NOC from the department. But the NOC which has been annexed here,
No, they have not stated that they have disclosed that they have obtained
They
a certificate from this Ludhiana Institute.
Ludhiana Institute in regular course, not in distance.
Is it their claim?
Yes, Lord. That is their claim. They are the regular case.
From where do you make this averment?
Lordship, paragraph 74, page 158. Lord.
158.
Yes, Lord.
Yes.
May I read?
Yes.
That the aforesaid observations and
This
findings
is
of the
what?
Lordship,
What is this?
this is the judgment
in
in earlier case, Lordship.
filed by them.
Yes, Lordship.
They would come here before.
Yes, Lordship. They have filed, means they have filed a writ petition accordingly. In violation of this writ petition, they have filed contempt also. And this is the second batch of writ petitions they have.
What was the cause of action in the earlier petition?
That was same, Lordship. That is the direction in the last paragraph of the page 168, Lordship.
It
has
starts
been-
at page
Yes.
105,
Lordship, the judgment starts from page
1110,
110
110,
109.
109.
Correct.
889 is by them. Oh, okay, some
Yes,
few of them. 2709.
Where petitioner number 1 was there as petitioner number 1 and petitioner number 2 is the petitioner number 7 in the earlier writ petition. That is in page 110, 110.
The same cause of action.
Lordship, same color.
What do you want to show in this judgment? Which paragraph?
Lordship, in paragraph 70, starting from paragraph 74, Lordship,
Page?
page 158.
Yes,
That the effort, may I read, Lordship?
yes, yes.
That the aforesaid observations and findings of the Honorable Supreme Court as regards deemed to be universities, that it is not permissible for them to impart technical courses through distance education mode, in the opinion of this court, would be equally applicable for any institute also, including the Institution of Civil Engineers, India, Ludhiana. In other words, Institution of Civil Engineers, Ludhiana, from where the petitioners obtained their certificate, could not have imparted any technical courses through distance mode without the specific permission or approval of the AICTE. The distinguishable feature in this case is that the Institution of Civil Engineers is an AICTE approved institution imparting education in technical education, unlike those deemed to be universities. Paragraph 75. The case of the petitioners thus is that the Institution of Civil Engineers, Ludhiana, being recognized by the AICTE, the certificates conferred by the state institutes are valid, and the petitioners did not obtain these certificates by way of distance mode. On the other hand, the case of the state respondent is that even though the petitioners have obtained the certificates from the state institute, recognition of which by the AICTE is not disputed by the state respondent, it is through distance mode, thus not valid, which, however, has been vehemently denied by the petitioners. Paragraph 76. As the respective submissions and counter submissions of the contesting parties have been already discussed in detail, it may not be necessary to reiterate here, except to observe that the state government insists that when permission was granted to the petitioners to undergo the technical course, it was to be under the distance mode without adversely affecting the normal official functions of the petitioners. The petitioners, however, have forcefully insisted that they did not obtain these certificates through distance education mode, as they had undergone the required practical and training courses through local institutes recognized by the Institutions of Civil Engineers, Ludhiana, which are also recognized by the AICTE. Paragraph 77. It is to be noted that whether Institution of Civil Engineers, Ludhiana, which confers the certificates to the petitioners, is recognized by the AICTE is not an issue here, in as much as the state government has not disputed this aspect. When the state government insists that the petitioners had not obtained their certificate by way of distance mode, which is denied by the I'm sorry, Lordship, that what the state government insists is that the petitioners had obtained their certificate by way of distance mode, which is denied by the petition.
Thereafter, What was the final order?
Final order, Lordship,
Correct. Page 165.
one. One fifty-five is there, Lordship, and starting from 165 till
Yes.
168.
You have to ascertain the degree, the certificate obtained. AICT is a party here.
Yes, is
What has the AICT, what is the stand?
You file an affidavit, right?
Madam, you're for AICT. What have you said? AICT, what have you stated?
Your lordship will file the affidavit, find the affidavit at page 80.
Are you with some senior or are you arguing on your own? Who? Please ask Mr. Kyle to come. It's an important issue. Now, is there any definite conclusion reached by the department along by clarification sought from the AICTE?
My lord, their stand is that we had written to the AICTE,
No, that we have seen.
yeah, and
that-
we have
that
not
we-
gotten a reply.
That we have read. What does the AICTE say? What
It-
have they said?
It has reiterated, my lord, that public notice regarding that public notice and state that, my lord, that your lordship will find that page 80, the affidavit starts. Page 81, paragraph 4. That the Minister of Human Resource Development Department, Government of India, through an order number such as 6/12/12, withdrew the recognition granted to all certificates qualification awarded by professional bodies institutions in the field of technical education. The MHRD further stipulated that from 1/6/2013 onwards, the courses for equivalence will cease to have effect in employment in central government, and the decision on the continuation of the certificate would be taken by the statutory regulatory body. So that, my lord, they have stated. Then, my lord, paragraph B, they say accordingly the course in its the council in its 52nd emergency meeting held on 3/8/2017 decided to recognize equivalence for all purposes, including higher education and employment to technical courses conducted by various professional bodies, institutions, which are duly recognized by MHRD with permanent recognition up to 31st May 2020. And they are reiterating that, my lord, public notice they have. So, my lord, it appears that from the affidavit that they don't need to give any further clarification. That is what it is meant by.
whether technical courses obtained to distance mode is valid or not.
It is not distance mode. my lord.
That part is not been clarified by the AS.
Let me complete my thought. I'll go to.
That part has not been clarified by the AS. And as per the contention of the Water Resource Department, they have stated, means the department is very clear that they have obtained the certificates to distance mode. Although that has been denied because from the NOC which the petitioner number 2 has obtained, your lordship has seen, it is only valid for distance mode without affecting the day-to-day activity of the department.
You require a regular course.
Yes, lordship, because this is a technical course. Engineering degree is a technical degree, lordship. For that, regular course has to be, means practical courses are to be needed. Practical exam means practical course is to be there. But they have not stated whether they have done the practical course or not, or despite of writing the department to them. We have stated in our affidavit. They have failed to produce any certificate they have obtained.
Mr. Chaudhary, you are saying that it is not a distance mode.
My lord.
That means it will require you to go and attend classes there at Ludhiana.
No, my lord. They have got a study center here, my
Where?
in Guwahati. In the, my lord, I have explained. I'll satisfy your lordship on all those points my lord, my friend has raised. It's not the distance education, there is, my lord, self-study and my lord, the study center here.
Self-study will not be a regular student.
My lord, I'll show you documents, my lord.
Do you need to attend classes on a regular
My lord,
basis?
that has been explained, my lord. The question that has been raised, my lord, then your lordship, in Odisha lift irrigation case, I'll explain that, my lord. Before that, my lord, the picture that emerges now is that the first question your lordship asked me, after this recommendation by the selection committee, why they are not promoting? The reason being, my lord, that was submitted by my learned friend in the affidavit, that there was a complaint by the, my lord, some association of assistant engineers. They had made a complaint, presumably, my lord, because if the 30% posts are not filled up, that comes to the, my lord, the direct recruitment. So that was the basis. Notwithstanding the fact that, my lord, all other departments, including, my lord, water resource department, had earlier recognized these courses and promoted persons. PWD, my lord, they did. Irrigation department, they have done, my lord. I have to annex all those, my lord, the orders passed by this honorable court.
No, but notwithstanding the complaint,
My lord.
for a timing, let us ignore the complaint.
Yes, my lord.
Now Odisha lift has come in.
Yes, my lord. Odisha litigation, what does it say, my lord? They are relying on only one paragraph, one or two paragraphs. I'll take your lordship to the, my lord, relevant paragraphs, my lord, which are necessary for, my lord, deciding the issuing controversy. In, my lord, Odisha lift irrigation case, paragraph 53, that has been, my lord, that was relied upon, that clearly states, my lord, it is regarding the deemed universities. Whatever observations have been made, if your lordship takes up their affidavit there, they have quoted it. It starts with that. In paragraph 7, page 215, they have quoted, my lord, paragraph 59. And paragraph 59, if your lordship kindly takes up the book, or, my lord, read from their affidavit at page 216.
Yes.
We therefore declare that in respect of students admitted after the academic session 2001-2005, the degrees in engineering awarded by the deemed to be universities concerned through distance education mode shall stand recall. This is in respect of, my lord, the deemed university. All India, my lord,
Paragraph?
paragraph 59, my lord. They have quoted there in their affidavit.
59, I think that is not SCC on time. That is not SCC, a different paragraph. We now move to second limb, no person.
In SCC, my lord, SCC, my lord, the paragraph is a little different. We therefore declare that in respect of court permit. Start. आरंभ ही होना है। वो भी है। Other for full center. And the different rates from it therefore declared reported. I'm sorry, but I did not mark it here. But based on the SCC will play access to paragraph 7. Printers to the people careful to play food. So that's what I
Direct, declared.
So that particular sentence, they have put it paragraph 59 is there, my paragraph 59 itself. But
Oh,
it
yes.
starts in the middle, my. It starts with as regards the student.
Yes, yes.
As regards the students who were admitted after the ex post facto approval granted in favor of such deemed to be universities, in
Mhm.
our view, there was no sanction whatsoever for their admission. The policy statement as well as warnings issued from time to time were all absolutely clear. The students were admitted on the strength of either of provisional recognition or on the strength of interim orders passed by the High Court. We therefore declare that in respect of the students admitted after the academic session 2001-2005, the degrees in engineering awarded by the deemed to be universities concerned to distance education mode shall stand recalled and be treated as cancelled. Any benefit which a candidate has secured as a result of such degrees in engineering in the nature of promotion or advancement in the career shall also stand recalled. However, if any monetary benefit so and so so.
Okay.
my lord,
What is this background of this particular institute? Ludhiana.
My lord, so far as before that, my lord, may I draw your losses reference to 2 paragraphs of original legislative.
Yes, yes. Awesome.
Paragraph 12, my lord.
Paragraph?
Paragraph 12, where, my lord, the UGC's affidavit has been quoted.
Paragraph 12.
That was the stand of the UGC. Then, my lord, paragraph 84,
Paragraph 12.
Paragraph. Before no, yes. Look at that, I think. Not going to cover it. That might put it.
But study center, as we normally understand,
Right.
will not be a regular course. You may have a study center, you collect your study materials, it's a self-study course. How can a study center be equated with a regular course? You can obtain a diploma from Assam Engineering Institute in Guwahati, Sanmari. It's a regular course, you have to attend classes. You can also obtain a diploma from a distant mode by self-study. Will it be, can you equate them?
My lord, that has been, my lord, the authority which decides it is the, my lord, the All India Council of Technical Education.
No, but when Odisha Lift in clear terms has said that all such degrees in engineering obtained after the session 21 to 2001 to 2005 are not to be recognized
In respect of, my lord, deemed universities, we are not.
of deemed university.
Yes, my lord.
So show us some literature about the Ludhiana
Yes, my
Institute.
lord. I am showing that, my lord. What, my lord, I want to draw your lordship attention is, my lord, paragraph 66.
Of Odisha,
Odisha Registration.
66, yes.
Ultimately, my lord, it has been, the issues have been addressed.
Hmm.
Paragraph 66. 66.2 is important, my lord.
Yes.
Insofar as candidates enrolled during the academic session 2001 in the present case access to approval granted by the UGC and their are satisfied. 66.4. AICT shall devise the modalities to conduct an appropriate test for those persons, my lord. Then 66.11. We restrain all deemed universities to carry on any courses in the distance education mode.
Hmm.
That is particular to, my lord, in respect of the, my lord, deemed university.
Yes.
We are professional, my lord, our institute is a professional body. Then 66.12, UGC is further directed to take appropriate steps and implement Section 23 UGC Act and restrain the deemed universities from using the word university within 1 month. So, my lord, this everything is confined to, my lord, the deemed universities. Now, so far as that question, my lord, that has come to your lordship's mind is that what about the training and what about the study? That has been, my lord, discussed in a subsequent judgment that has been, my lord, explained. Now, your lordship will kindly note, my lord, the citation is 2019-16 SCC.
Yes.
2019 volume 16 SCC, page 95. Institution of Mechanical Engineers versus the state of Punjab. So Institution of Mechanical Engineers is also, my lord, a professional body like that, my lord, the institute from which the petitioners have obtained their diploma. And your lordship may kindly also note the fact that the composition of the bench, the Odisha Lift Irrigation case was decided by Honorable Justice Adarsh Kumar Goel and Uday Lalit. And this, my lord, 2019-16 SSC 95, Institute of Mechanical Engineers, this is by Honorable Justice U. Lalit and Deepak Gupta. So, U. Lalit is there in both the cases.
Yes. Now, is it a case by the Ludhiana Institute? No.
No, my lord, but it is a similar, my lord, professional body, not a deemed university.
No, it depends on the university. One may be deemed, one may be a professional university. Show us your university.
No, my lord, I'm showing the, my lord, what is observed in this case regarding that, my lord, training part and, my lord, attending classes.
Paragraph?
Paragraph 49. Your lordship may also read, my lord, paragraph 48.
48.
48, my lord.
Yes.
The High Court was therefore right in observing that The Institute of Mechanical Engineers India, Mumbai is a registered society and is thus a technical institution and is required to obtain approval from 8A in respect of its courses in technical subjects. The membership of such institute cannot be treated as equivalent to a degree, as the candidates qualified from such institute cannot be said to be on par with the members of the Institute of Engineers established under the statute. Then paragraph 49. However, the fact remains that the equivalence to the certificates awarded by the appellant was granted by MHRD. In our case also, my lord, MHRD has given in consultation with the 8A, same thing, my lord, up to 31/5/2013, same date, as is evident from the notification that is 6/12/2012 issued by the central government and public notice issued by the 18 August 2017 that your lordship has already seen. This communications also indicate that all those students who were enrolled up to 31/5/2013 would be eligible for consideration in accordance with MHRD Office Memorandum Order in course. Though we have laid down that the certificate issued by the appellant on successful completion of its biannual examination to its members cannot be considered to be equivalent to a degree, an exception needs to be made in favor of the students enrolled up to 31/5/2013 and benefit in terms of notification dated 6/12/2012 and public notice as aforesaid ought to be extended to such. The candidates had opted to enroll themselves so that they could appear at the examination conducted by the appellant under a regime which was put in place by the central government itself, and the course content as well as the curriculum were reviewed by 8A. However, the aforementioned notification and public notice were clear that after 1/6/2013, the order concerned granting equivalence would cease to have any effect. In these circumstances, we do make an exception in favor of such candidates enrolled up to 31/5/2013 and declare that the conclusions drawn in the present matter will apply after 1/6/2013. The certificates awarded by the appellant to such candidates enrolled up to 31/5/2013 shall be considered equivalent to a degree in mechanical engineering for the purpose of employment in central government. Now, so far as this institute is concerned and my lord, the distance course, your lordship had put the query. May I draw your lordship's attention to one clarification, which is at page 106 of the read petition.
(106). Yes.
This is a communication issued by the my lord All India Council of Technical Education and issued to the Director of Technical Education, Assam. Subject clarification regarding recognition of Institute of Civil Engineers India, Ludhiana, Punjab. Has your lordship got it?
Yes, yes.
Dear sir, please refer to your memo number so and so on the above subject. We'd like to inform you that MHRD via its office memorandum number so and so dated 6/12/2012, copy and close, has withdrawn the recognition given to the courses conducted by professional bodies, institutions such as ICE, etc. Only those students who are enrolled with the permanent recognition up to 31/5/2013 with their professional bodies would be eligible for consideration pertaining to their courses for equivalence in central government jobs. However, MHRD has referred the matter to 8A for review, and accordingly, 8A has constituted a standing committee to review the courses conducted by various professional bodies, institutions, and it has been decided by the committee to obtain information from professional bodies, institutions conducting technical education. The matter was also discussed in the council meeting of 8A. After due deliberations, it was resolved that prior to 31/5/2013, as mentioned in the aforesaid notification dated 6/12/2012, all such equivalents already issued in the past by the MHRD may be recognized for all purposes, higher education and job, and this may be informed to MHRD. Further, the council also decided that the committee looking into the matter may devise parameters and process to take up the recognition of all professional societies individually regarding past 31/5/2015 scenario in respect of all such professional societies bodies conducting technical education courses and conducting examination and are affected by the MS30's OM dated 6/12/2012. 6/12/2012 notification is at page 103. Now, my lord, your lordship has seen the only ground on which, my lord, we are deprived is that, my lord, Orissa litigation case. And this matter, Institute of Mechanical Engineers has, my lord, explained. And after this clarification from the 8th on the ground that we have not received any clarification on the 8th, my lord, they are sitting over the matter. And this honorable court in the earlier litigation directed that you submit all the papers to the authorities, and we have submitted, we have been making representation, nothing has been done. And that is why, my lord, we are before your lordship again. And in fact, my lord, we filed a contempt petition because in the earlier proceeding, my lord, 8K was not a party. Then in the contempt petition, this honorable court observed that you make 8K a party and you can approach this court again. And the contempt was closed. Accordingly, my lord, we have filed this petition making 8K a party because, my lord, according to the department, clarification was not coming from 8K as was directed by the honorable court in the earlier litigation, and therefore we are not acting upon the recommendation of the promotion committee or the board, selection board. Now, after all the clarifications from the, my lord, the Minister of Human Resources and the 8K, my lord, nothing remains to be clarified. So, my lord, the first ground they have taken in the first affidavit, my lord, was regarding the, my lord, the ratio laid down by the, in the, my lord, Orissa litigation case. That, my lord, perhaps I have been able to explain or satisfy your lordship, my lord, in view of the subsequent clarification given, my lord, in the Institute of Mechanical Engineers case, my lord, that falls true. And in the subsequent affidavit, my lord, the ground taken is that the no objection regarding the no objection that your lordship has already, my lord. Now here is a case, my lord, all the departments of the state of Assam, including, my lord, agriculture, my lord, the water resource department, they have acted upon this, and now, my lord, they are taking this ground and that ground, and they are not acting upon this. In fact, my lord, the other day in the other case, my lord, I have placed your lordship judgment on judgment in Panchayat and Rural Department that was regarding when the, my lord, the seniority will take place. There, your lordship has noticed that, my lord, the Panchayat and Rural Department and had recognized and given recognized this court and given promotion. So, my lord, PWD, the Irrigation Department, Panchayat, and even, my lord, the Water Resource Department on earlier occasions, they have recognized this.
No, in that case, the degree was not the
That was not the
subject
issue.
matter of the issue.
That was
They were
not the-
already given appointment,
Yes.
but it was only giving when to give the effect.
Yes, my lord. But then, my lord, your lordship has observed that they have already accepted that and they have given the benefit. Only, my lord,
That was the department's. Yes, you may be right in contending that all other departments are giving.
yes, my lord. Even, my lord, Water Resource Department, my lord, the minors of the selection committee also noted, my lord, earlier the persons were given. And the persons, my lord, who were selected in that selection committee, my lord, except the persons who are from the, my lord, the institute at Ludhiana, other persons have been given the promotion.
Those persons were lucky. Their promotions were prior to this decision in Orissa lift. Those PNRD.
Yes, in PNRD, my lord, it was right. No, but then, my lord,
But even Orissa lift has said that persons who have been given promotion, those are to be cancelled.
yes, that they have
Monetary
to,
benefit, don't give,
yes,
don't recover, but you cancel.
and they have to appear again for the, my lord, case.
They were lucky,
In a
not
sense, yes.
detected,
In a sense, yes.
not detected.
Now, these two persons have been,
Mr. Kyle, you will play a very crucial role. You are missing.
But we have taken stand that those students who have taken admission up to 31/5/2020. This course has been
That you have, there is a public notice also.
Yes, sir.
After Odisha lift.
Yes.
That Mr. Chaudhary has shown.
And we explain in paragraph 4 of our.
As per you, it's a valid degree.
Yes. There is no valid, their courses by them are also considered to be valid.
In the earlier round of litigation, when the matter was remanded, what was the exact
Regarding the practical courses, sir, it has been- paragraph 4 of it.
same preservation? We come to 158, 74, and 75. Okay, no. Come to 85. 79, I think 79 or 85. Come to 79 first, at page 160.
Accordingly,
In view of the peculiar nature of the dispute, please read.
Court is of the opinion that as is the most appropriate to determine together a certificate obtained by the petitioner from senior Yana. Recognized by SCT were obtained through identification mode. Sir, these were as per the norms of the SCT. Hence, fortunately, in present case, these have not treated the SCT as a respondent because of which court is not able to determine the stage definite.
What was your stand, Mr. Das, in the earlier case?
It may kindly come to
This
paragraph-
stand more, okay. Now you have to clarify, it's not the validity of the degree, Mr. Kyle. Whether degrees are valid to a particular date. The onus was upon you to inform the court or rather the authorities that whether these particular certificates are obtained by distance education mode or by a normal regular course. We will not go beyond what the court, what the parameters or the contours the court has laid down in the earlier judgment. Come to 79. You've just read 79 at 160. And just prior to that, one paragraph prior to that, 77, just turn over the page.
It is to be noted that the Institute of Civil Engineers
Is recognized is not the issue. See, that is not even the issue. Issue is whether, and that is not whether since the petitioner has obtained the distance education mode. Validity of the degree is not the issue. They have been consistently holding that we are not allowing distance education mode. Court did not say that yes, your stand is an erroneous one or invalid one. Rather, it left to IICT to come to express your opinion whether this is a distance mode education.
But in ideal litigation, we were not party. In this case, we are party.
No, no. What do you say on the distance mode?
If that particularly that point is
That is the only only point you have to, because you are not going back to the validity of the degree. Validity is valid as per your notification.
it is there. Its validity there is no question. Regarding that,
And one more thing, why we are emphasizing on this, court on the previous occasion had observed that that was not even the issue, validity. So whether they are saying valid, they are saying invalid will not do. It's valid. But whether it was obtained through a normal course or a distance education, distance mode. Mr. Chaudhary is trying to say that they have centers in Guwahati or wherever, and they had obtained it through normal, as a normal student, irregular student.
page 44, 43 and 44
Of
of the petition. the Institute of Civil Engineer India.
43. 43?
43, the certificate produced by the petitioner.
Yes.
Rohini Spencer, member of health, past Spencer, member of petition AMIC in civil engineering. So they obtain their degree from attending the class of associate member examination conducted by Ludhiana. Associate membership examination is organized by the Ministry of Human Resources of India. From they obtain the degree by attending classes.
Now we had put a question to Mr. Chaudhary that did you leave your work and go work at Ludhiana? He said that the classes, the centers were at Guwahati.
That is reflected from this certificate.
Where?
If Rohini petition number has passed ABN of associate members examination in civil engineering held in the winter of section A and B of the associate members of examination is recognized by the Ministry of Human Resources. In India, which of equivalent degree in civil engineering. The member has undergone practical training, tests, and project work in the ICT approved engineering institute and has obtained.
This is distance mode. But it's up to you. How you have to say. You are the expert.
Well, time
that is the only question. We are keeping this part hard.
Please reflect in the order so it will be.
Yes, yes. No, that was the direction in the earlier order itself.
No, we have direct to.
Your letter to the DT is not on this issue at all. Your letter to the DT is on the validity of the
Yes,
certificate.
Validity
Validity was not even the question in the earlier round of litigation. Not here also. And the distance mode factor, suppose tomorrow the version of AICT is against the petitioner, then another question will arise. When you are accepting the same certificate for other departments, two departments cannot act differently. You are part of the government.
Yes.
Why you have taken this decision? Recently, we have held in a matter pertaining to a PSU that the certificate obtained through distance mode was not accepted by the PSU. We have agreed with them. That is your prerogative. Now here it's one department vis-a-vis other departments.
That was in Rupok.
And incidentally, in the case of PNRD, which this court was involved, we had come across promotions affected of persons who had obtained certificates from the same institute, Ludhiana. So under those, that also you need to clarify. But whether that question we can go in view of the findings arrived in the earlier round of litigation. Earlier round has sealed this issue. But since this has come up, you need to at least have some kind of explanation. Why this discriminatory attitude of the same government?
May I, my lord, before your lordship court with the court, may I, your lordship, two clarifications given by the, my lord, the institute, that your lordship will find at page 91. 911.
Yes.
This was written by the institute to the, my lord, Water Resource Department. Because they wanted to know whether it is a distance mode or not.
Yes.
Please refer to your letter number such and such and other details about the authenticity and qualification obtained through ICE are given below. The Ministry of Human Resource Development, the Apex Ministry of the Government of India, by this Gazette notification number such and such, the 6 November 2007 gave recognition to the section A and B associate membership course equivalent to degree.
Paragraph 3, I think it'll help you.
Paragraph 3.
Paragraph 3.
Recognition to the course. Samala, this is not, we do not offer these courses through distance education mode. Then, my lord, Orissa leaf irrigation has also been, my lord, stated here. And another document, my lord, in their syllabus, 107, my lord. 107, that is an extract from the, my lord.
The earlier judgment is of which date? The assessing judgment,
WPC
889, 109
my-
is, what is the date?
24/1/2020.
24/1/20. This,
That time, my lord, the Institute of Mechanical Engineers did not come. That is perfect.
no, what about this clarification? This was with you. This was not pointed out, page 91.
It was there in the record.
But this was maybe from the institute, so it is the left to the AICT, yes. Heard Sri M.K. Chaudhary, Learned Senior Counsel for the petitioners. Also heard Sri R.M. Das, Learned Standing Counsel, Water Resource Department, as well as Sri S.C. Kail, Learned Counsel, appearing for the AICTE. Respond number 6. Full stop. This is the second para. This is the second round of litigation pertaining to a claim for promotion from the post of junior engineer in the department to assistant engineer. Full stop. The claim is based on a provision in the rules, namely Rule 11.5. 11 within bracket 5. Full stop. It is the case of the petitioners. Please have a seat. That the selection committee in its meeting held on 27/2/2017 had recommended the names of the petitioners for promotion, which were to be treated as direct recruitment as per the rules. Full stop. However, in spite of such recommendation, the promotions were not effected, as a result of which they had earlier approached this court along with some others by filing WPC 889 of 2018. Full stop. The department had taken a stand that the certificates which are equivalent to a degree were obtained by distance mode. Full stop. On the said issue, this court in the judgment dated 24/1/2020 had directed the matter to be clarified by the AICTE. Full stop. For ready reference, the relevant part of the judgment is extracted herein below. Page 160-79. Para. Though a contempt petition was instituted, the same was subsequently withdrawn with a liberty to raise the grievance by impleading the AICTE, and accordingly, the instant writ petition has been filed. Full stop. Though the AICTE has filed affidavit in opposition, the aforesaid point pertaining to whether the institute in question, namely the Ludhiana
Institute of Civil Engineers.
Yes, we have written. The Institute of Civil Engineers,
India.
Ludhiana,
Punjab.
imparts course by distance mode. Full stop. The petitioners have also relied upon a clarification given by the institute dated 310, correct? 310-17.
This is 17/4/2018,
Oh, so
page
sorry.
91.
Oh, sorry. 17/4/2018. Full stop. Para. Let specific instructions be taken, be obtained by Sri Kyle, the learned counsel, on the aforesaid issue. Full stop. List on when?
10 days.
We fix a date.
No.
We'll have it on 6th of September. You get more than 10 days. 6th September.
A copy of the order.
You have it online copy nowadays. Why do you ask for a copy?
Your lordship perhaps has not recorded that it is format.
For further consideration.
Highly appreciate.
Hey, to control. On piece or go to my city and I get you. Item number? Yes.
My lord, on the last page and the original
Records.
record.
Okay. Yes, what is the matter?
Pursuant to a disciplinary inquiry, the petitioner who was working as an assistant manager in the State Bank of India
Petitioner is
working as an assistant manager in the State Bank of India has been imposed the punishment of reduction to lower stage in the time scale of pay by stage for 1 year, with further directions that the officer will not earn increments to pay during the period of such reduction, and on the expiry of such period, the reduction will not have the effect of postponing the future increments.
without
of
cumulative
pay.
effect. Without cumulative
Without
effect.
you.
But that increment part perhaps will not have too much of a meaning. But lowering to a lower reduction to a lower stage,
Yeah.
that is affecting you.
Lordship, the basic case of the petitioner is that this punishment has been imposed upon him, although there is no evidence to implicate him to enable the authorities to impose the punishment. For that, Lordship will have to examine the records of the disciplinary proceedings.
First, tell us what are the
Yes,
charges?
Lordship may kindly see Annexure 7.
You are working where? Assistant manager where?
At that time, the petitioner was working at Titawar branch, Jorhat district. Lordship may kindly see Annexure 7.
7.
Yes, at
Page?
page 50.
50.
Yes. Prior to that, he was issued with a show cause notice. He filed reply.
Yes.
That was not found to be acceptable. That's why the disciplinary authority decided to initiate disciplinary proceedings.
Okay.
Initially,
a fact-finding inquiry was done.
Not fact-finding inquiry. He was issued with a notice.
Explanation.
Yes, and he submitted reply. That was not found to be sufficient.
So at 50, page 50 is the formal
Yes,
charge sheet.
charge sheet. Please refer to letter number so-and-so dated 21/6/2012 served on you relating to the article of charge and the statement of allegations as alleged against you while you were working as assistant manager at Titawar branch. Your submission in response by your letter dated so and so is not found to be acceptable. I am therefore of the
Let us
opinion.
come to the charge.
Yes. Lordship will kindly see. Charge is, that was earlier.
But this is not the charge sheet, this is going ahead with the inquiry.
Inquiry.
because,
The statement of imputation of
Wait, wait.
lapses, that is at page 45, Lordship.
Come to that. 4-5.
Yes.
Come to 43, that is the main. It is not the explanation, this is the initial show cause. 43,
Oh, yes. It has been,
21-6.
Ah.
Show cause notice.
yes. He replied to it, that was not,
Now, let us see what are the
that starts from 45.
statement of allegation. 44. During your tenure as
Eh,
assistant
ah.
failed to discharge the written result manner.
The allegations are there at page 45.
Loss.
May I read it, Lordship?
Statement of allegation, yes.
Yes. That on 12/10/2011, you had accepted one non-home branch MBS registration application, that is mobile banking service registration application form in respect of account number so and so of the Deepak Pakia maintained at AAU branch, Jorhat, from Sri Dipul Bora, generator operator of Titabora branch, and authorized the same in CBS. Your registered mobile number so and so, you registered mobile number so and so for mobile banking service against savings bank account number so and so of the Deepak Pakia maintained at AAU branch without cross verification of mobile number which appeared as so and so available in CIF level. Thus, you were negligent and failed to carry out the extent instructions of the bank. That is the allegation number 1.
Okay.
He has registered a different mobile number pursuant to an application made by this gentleman, Deepak Pakia. Although his registered mobile number with the bank was different.
Yes.
The registered mobile number of Deepak Soikia was
Now,
94.
that we have seen.
Yes.
Allegation 2.
Yes. Allegation 2 is that you have failed to take due diligence and precaution while registering MBS for non-home branch account. As per bank's extant instructions, the registration of mobile banking service can be done at home branch only of the main primary account selected by the customer. Thus, you were not only negligent but failed to carry out the laid down instructions of the bank. In fact, it is a continuation of allegation number 1.
Yes.
Then the third allegation is
Yes.
that on 12/10/2011,
Yes.
13/10/2011, and 17/10/2011, an amount of rupees 40,000 in each occasion was fraudulently transferred from account number so and so of the same person, the Deepak Pakia, through MBS to account number so and so of Srimati Alpana Gogoi, which is being maintained with Titabor branch. The total amount of 1,20,000 were subsequently withdrawn through various ATMs on different dates. by using the ATM card of Srimati Alpana Gogoi, which was surrendered by Srimati Gogoi on 14/12/2010 at Titapur branch. You thus did not discharge your duties with utmost sincerity, devotion, and diligence, and thereby committed lapses of very serious nature, resulting into probable financial loss to the bank to the tune of rupees 1.20 lakh, besides jeoparding the image interest of the bank. This lady, Alpana Gogoi, she had surrendered her ATM card. And this ATM card was used to transfer an amount of 1,20,000 in 3 equal installments of 40,000 each to the account of Sri Deepak Sarkar.
No.
To the account of Alpana Gogoi from Deepak Sarkar's account.
Yes.
From Deepak Sarkar.
Now, how was Alpana Gogoi's ATM relevant? The victim would be Deepak Shaikia, because the amount of 40,000 each on 3 dates were transferred through MBS, mobile banking scheme, to account of Alpana Gogoi. Alpana is the beneficiary.
Yes.
The total amount was subsequently withdrawn through various ATMs on different dates by using ATM surrendered by so-and-so. Okay. How are you connected with the withdrawal of this amount from Alpana Gogoi's account?
The allegation against me is that the ATM card was surrendered by Alpana. And me being the assistant manager, I did not destroy the ATM.
Okay.
The next allegation is that you did not immediately, it is a continuation of allegation 3.
Yes.
That you did not immediately hotlist, deactivate, and destroy the ATM card number so-and-so, issued against account number so-and-so of Srimati Alpana Gogoi, Titapur branch, surrendered by Srimati Alpana Gogoi on 14/12/2010 at the branch. The fraudster had utilized the lapses deficiencies committed by you in connection with the surrendered ATM card and perpetrated the fraud. You neither recorded the details of the surrendered ATM card of Srimati Alpana Gogoi in a separate register, nor made any attempt to deactivate and destroy the surrendered ATM card, but very casually kept the said card in a file along with the application form, thereby exposed the bank to grave risk. And the list of documents and
Okay.
list of witnesses were also given.
Yes.
Then I submitted my reply, Lordship, Annexure 6, page 47.
Yes.
May I read it?
No, not required. We'll just have a cursory glance.
No, Lordship, this is very important, Lordship. It
Okay.
has to be seen in detail.
Please read.
With reference to the above, I humbly submit hereunder in seriatim the reply to the charges leveled against me. As per the branch record, I have come to understand that in the branch review meeting held on 28/2011 to increase mobile banking sourcing. At that time, mobile banking was introduced for the first time in State Bank. to increase mobile banking sourcing by Sri Dipul Bora, generator operator. He will be assisted by Malin Pegu, assistant, and authorization will be done by branch manager, accountant, and cash officer. The practice at the branch is that preliminary works of verifying, scrutinizing the application of MBS in the branch were being done by Sri Dipul Bora and Malin Pegu. For all applications that were sourced by Sri Dipul Bora, which is evident from registration forms, the erstwhile branch manager, Mr. Iqbal Islam, had no doubt about the integrity of Sri Dipul Bora and has entrusted the task of sourcing MBS totally to Sri Dipul Bora. Such was the trust and sentiment that the erstwhile branch manager, Mr. Iqbal Islam, on getting relieved, had told the new branch manager that if at all the branch receives any reward on account of MBS, then Dipul Bora must be the worthy recipient of that reward. And that is why Sri Dipul Bora, a generator operator and not related to branch by any means, got the chance to free access in all part of the branch, including MBS and other messengerical works. Therefore, when a branch manager who has all the discretionary power in the branch had appointed a generator operator to Dipul Bora for outsourcing of MBS, then there is no any question of doubt about the integrity of Sri Dipul Bora. Under these circumstances, and with this background in view, and on that day, being the only officer in the branch, as I was totally overburdened with various works of the branch, and having verified the signature in CBS, which has tallied with the signature in the MBS application form, and as the preliminary works of verifying / scrutiny of the application were done by either Dipul Bora or Sri Malin Pegu, I rushed through the job without seeing the mobile number. Also, sir, there is no any specific guideline or restriction that one customer cannot register his/her mobile number, which was provided in CBS. And here I want to mention that while registering mobile number for MBS in CBS system, the CBS never asked for any supervisor ID or restriction for non-home account, like all other non-home works, where either CBS system not allowed at all showing non-home account or asking of supervising ID for passing the non-home restriction. For example, while we put on request for ATM card for non-home branch, it does not allow showing non-home account. Also, there is no any provision in CBS till date to verify the mobile number belongs to whom. For example, PAN number can verify in CBS system. Moreover, the system allowed with the asking for any restriction for non-home branch. Lordship, at that time, mobile banking was newly introduced in State Bank of India. So now, Your Lordship, after this fraud has taken place, State Bank has improved upon the system. Now, if I use another phone number other than my registered phone number, asking for mobile banking service, the bank will refuse. At that time, the system was not so. And now, if I ask for mobile banking service, I will have to go to my branch where my account is. But at that time, these checks and balances were not there when it was introduced for the first time. And after this fraud, Lordship will see in the review application where my punishment was reduced, the reviewing authority had taken note of that fact. This is a very relevant consideration, Your Lordship. Lordship, next. Then he has replied to that. Task number 2. As explained above in item number 1 and 2, allegation in this item is not related to me. Moreover, the entire amount has been recovered by Sri Dinanath Bora, father of the miscreant generator operator. While what happened is that, Lordship, this Vipul Bora, he stole the ATM card because he had access, Lordship has seen, access to all areas of the branch. The ATM card was in the custody of the branch manager. So Vipul Bora stole the ATM card and he withdrew money.
What about the password? ATM, my ATM, you can use my ATM.
I don't know how he did it because that password question has nowhere come. Neither in the charge
But it
sheet,
is you have stated that the amount has been recovered from the father of the miscreant.
because the father was an employee of the bank at Assam Agricultural University Jorhat branch. So this bank people caught his father saying that your son has fraudulently withdrawn. He was working as a generator operator in the Titabo branch and his father made good the loss. I'll come to all that, your lord. Everything is on record.
Thereafter,
After receiving that, then the second, that non-destroyal of ATM card. After receiving the application for replacement of the ATM card, the old card was kept in a file with the application by punching it with stapler, as was the prevailing practice in the branch. And it was recorded in the proper register at the same time. The file was kept in the record room. The keys were in the custody of the then branch manager, Mr. Iqbal Islam, where anyone in the branch had access without maintaining any in-out register for record file or any other stationery, as Sri Dipul Bora, generator operator, was nominated by then branch manager Iqbal Islam. And by that support, Sri Dipul Bora had, wrong English, had got free access in each and every part of the branch in terms of messengerical work. That is why Sri Dipul Bora got ample scope to obtain the surrendered ATM card from the safe custody of the then branch manager. As per the prevailing practice of the branch, we always provide the customers 3 customer care numbers to hot listing so that the card was not hot listed, destroyed, but kept under proper custody of the then branch manager Iqbal Islam. That's it may be appreciated that the investigating report alleged allegation framed on me appeals to be partial, as the following were not taken into consideration. The statement and question answer obtained from the staff on 3 different dates. The other facts and figures and evidences have not been highlighted, and all this. Lordship will now come to, Lordship will see then inquiry was initiated. An inquiry officer was appointed. Defense assistance was also given. And presenting officer was also there. All this, that is there in Annexure 7. Lordship will kindly next see Annexure 8. That is the minutes of the proceedings of the inquiry. That is very important. Annexure 8 at page 52. May I read it, Lordship? Minutes of the proceedings of the disciplinary inquiry against...
Entire thing you need not read.
Lordship, it is very important, Lordship.
No, first, good morning, sirs. Please take your
No, all
seat.
that
Will
is
you
not
read this?
required. All that is
Read
not
the relevant part.
Yes, yes. You may please call your witnesses one by one.
Not required.
Yeah.
Come to the main part.
Please go ahead. So the first witness for the management is the subsequent branch manager. The earlier branch manager was transferred by then. Sri Bora, you were the branch manager of the branch. From when you were branch manager of Titabo branch, since 1/10/2011, I have been the branch manager of Titabo branch. Do you know Sri Dipul Bora and what were his duties in Titabo branch in October 2011? Yes, he was a generator operator employed by the owner of the generator. He was also sourcing mobile banking applications from customers as instructed by the previous branch manager, as evidenced in post-review meeting proceedings dated 28, 2011. Is there any office order to Sri Rajagopal Dhar for doing mobile banking authorization on 12/10/2011? No specific order for Sri Rajagopal Dhar for authorizing mobile banking, but it is evidence from the proceeding of post fee review meeting dated 28, 2011 that the branch manager, accountant / cashier can authorize. Please refer to prosecution exhibit A, mobile banking application form of the Deepak Toikia, non-home branch account number so and so. This Deepak Toikia, he had his account at the Assam Agricultural University branch, and he applied for mobile banking at Titavur branch. At that time, probably it was permissible. Now it is not. Source register at your branch. Now please tell me whose signature appears. Is there any authorized official? This is the signature of Sri Rajagopal Dhar. Please refer prosecution exhibit 8 again and prosecution exhibit 16 and tell whether mobile number appearing in these two forms are same or not. They are not the same. In prosecution exhibit 8, it is so and so. In prosecution exhibit 16, it is so and so. So in the records of the branch, the earlier
Why
mobile
you are
number.
not going by the evidence and the manner you are trying to portray. We are having a say, exercising secondary role.
No,
It's the authorities of the primary role is performed by the
Lordship,
disciplinary authority.
Lordship, the law is that
You show us if there is something gross irregularity in the procedure
there is
adopted.
vast irregularity.
We are not going to appreciate evidence in a disciplinary proceeding case
Lordship,
under 226.
if there is no evidence of any kind whatsoever against a delinquent individual, a lordship exercising powers under Article 226 will definitely interfere. That is the law. And that my earnest endeavor is to read this is to convince your lordship that there is no evidence.
This
against
amounts to appreciating evidence.
There is no evidence of any kind, lordship.
That you are free to make the contention that there is no evidence.
Yes. So unless I show the records before your lordship, probably I won't be able to convince your lordship that there is no evidence. That is my.
We have seen the charges. Charges are not that serious in nature.
Yeah.
And how much you are involved, that is also a matter we'll get the clarification from Mr. Talukdar.
Yeah.
Because your role was a different role.
My
One
role.
person was a generator operator. He was given the powers to
Authorize mobile. He was authorized.
Increase the numbers of customers
Yes.
who goes for mobile banking services.
Mobile banking.
And while doing so, he had opened a mobile banking service for one of the customer with a wrong phone number. And you
The
had
customer has given a different phone number and he has
not
accepted.
verified. That
he
is
has
the
accepted.
allegation. And from that account, certain amounts have been transferred to account of another person, and using the ATM card, surrendered ATM card of that other person, 1,20,000 has been extracted on 3 installments. That is the
Lordship, the most important thing is that just because I have registered a different phone number, because of that, the fraud cannot be perpetuated. Fraud has been perpetuated in a different manner.
that we have understood. Let us see the impugned order.
Yeah.
How after this you are given a second show cause.
Oh, yes.
Let us see the inquiry report.
Yes. Lordship will kindly see.
After the proceedings, what report did he give?
Lordship, Annexure 11, page 91.
9-1.
91.
Okay. And the allegation is clearly.
Allegation 1.
Oh.
Allegation 1 is proof that I have registered a different mobile number. Allegation 2, that I did not follow the laid down procedures of the bank. That is also proof.
Yes.
Allegation 3. Sorry, Lordship, the first allegation is not proof. The second allegation is also not proof.
No, that is by the inquiry officer.
Yeah, inquiry.
No,
Now,
this is by the.
later on, the disciplinary authority has disagreed with the findings of the inquiry. This is the findings of the inquiry.
Okay, thereafter.
Thereafter, he was issued with a notice and the punishment has been imposed. And he filed an appeal. In appeal, the punishment was modified. Lordship, the disciplinary authority has disagreed with the findings of the inquiry officer, saying that the petitioner is responsible because this Dipul Bora, he could steal the ATM card and consequent withdrawal of the cash withdrawal. Lordship, it was not the responsibility of the petitioner to maintain safe custody of the ATM card. It was the responsibility of the branch manager. That is why I wanted to show the records of the inquiry.
Where is the penalty order?
Kindly. Hmm? Lordship, page 119, annexure 22.
119.
Here. Annexure 22.
Okay.
Reduction to a lowest stage in the time scale of pay by one stage for a period of 1 year, with further directions that the officer will not earn increments to pay during the period of such reduction, and on the expiry of such period, reduction will have the effect of postponing future increments of its pay. And this has been modified, or been appealed.
Where is the appellate order?
Lordship, I am coming. On 29, 131, I am told. Lordship will kindly see the relevant portion, 132 page. Lordship, the last but one paragraph, middle portion. I am inclined to take a lenient view and feel that ends of justice will be met with the modified penalty of reduction to lower stage in the time scale of pay by one stage for 1 year with further directions that the officer will not earn increments to pay during the period of such reduction, and on the expiry of such period, reduction will not have the effect of postponing future increments of pay. Previously, I think you will have the effect. Previously, it was will have the effects of postponing future increments of pay. Now it is
You filed for review also.
a year. I have exhausted all remedies, Lord.
What is the order in review
Review has said that there is no reason to interpret.
with the appellate?
Yes. Lordship, but they take note of the fact that at that time, the system allowed it. Lordship will kindly see page 143.
Okay. Okay, what are your grounds?
Grounds, my
First-
case is that it is a case of no evidence. There is no evidence to implicate the petitioner because of the fraud which was sought to be perpetuated by this generator operator, Vipul Bora.
No, that is one part regarding the money involved.
Yes.
So far as not verifying the phone number, that is also an allegation.
Because the,
We're only trying to express what you are saying. We
Yeah.
have not expressed anything, whether that can be a charge at all.
yes.
Oh.
So my contention is that at that time, the system allowed it. At that time, the system allowed it. On that fateful day, I was the only officer in the bank manning the entire bank. I was the only officer. And this scrutiny of this mobile number was done by this Dipul Bora and Malin Pegu. And I checked the signature of the customer in the application form and also in the CBS, in the CIF. And the signature tallied. The mobile number I did not check. Mobile number was checked by Malin Pegu and this Dipul Bora. I relied on their judgment, and I am being faulted on that count. That is my only fault, Lordship. And it was a fault of the system. The system ought not to have allowed that. And later on after this incident, the bank had modified it. That is why, Lordship, I was showing page 143. The reviewing authority had taken note of that fact. Sri Dhar contended that the system of registration of mobile banking service for customers have changed and revised considerably by the bank after this unfortunate incident. This aspect taken into consideration while disposing the appeal preferred by the official of the appellate authority. Because the system allowed it, and this was contrary to the international banking norms at that relevant time. That also I have annexed, Lordship, in my affidavit in reply. Lordship will kindly see my affidavit in reply. That is the only lapse on the part of the petitioner. Otherwise, it was the duty of the branch manager to maintain safe custody of the ATM card. The branch manager had failed to do so, and the petitioner has been made a scapegoat, Lordship. That is my specific case.
See, effectively, since cumulative effect was not given,
Yes.
you are not otherwise affected, except the stigma part.
Stigma part, and I have lost some increment.
You will not lose.
I have lost at that time.
No, it is not postponing. It is not a cumulative effect.
It was not cumulative effect. For that particular year, I have lost.
Next year you'll be getting everything.
But next year I'll be getting for that year only,
No.
not the year which I have lost.
No, if it's not a cumulative effect, you'll get back everything after. It's only for that period. You'll be, that it has been deferred by one year. Yes, Mr. Talukdar. Is it a case of imposing penalty?
Lordship, so far that part, your lordship has already.
Okay, we'll come back.
But I cannot 3 and 4, my lord. My pen is there, my lord. R. Muzumdar, my lord.
Yes.
I have received the record, my lord. It's only this in vernacular, my lord. So I have not able to read, my lord. So sometime, my lord, if allowed, my lord, 2nd of September, my lord.
I'll also take the opportunity to go through it.
Okay, 3 and 4, like, Ahad Sri R. Mazumdar, learned counsel for the petitioner. Same petitioner.
Two different
petitioners.
same proceeding.
Same petitioner. Sri S.K. Mithi, learned CGC, has however informed that though the records have been received, the same, he needs some time to go through the same as it is in vernacular. Full stop. Para. As prayed for. List on
Second, my lord. Second.
Monday, we'll have it on, okay, 2nd of September?
Yes.
Okay.
Lordship submission, another matter, my lord, item 8, 9, 10.
Yes, you are there.
A last opportunity was given to me to file my affidavit in reply.
Yes.
But I've got a medical certificate from the petitioner. He is in the hospital of the respondents for his psychiatric treatment. But I require some more time to file my reply. He is admitted to their hospital.
Okay. Sri R. Mazumdar, learned counsel for the petitioner in these cases, that I petitioner, submits that though time was granted to file reply affidavit, the petitioner is suffering from certain ailment and has been hospitalized. Hospitalized?
Oh, he's hospitalized.
Hospitalized. Full stop. Learned counsel accordingly prays for and is granted 2 weeks further time to file the affidavit of opposition. Madam, 2 weeks. Why? Interim order is there or what?
Yes, my lord. The disciplinary proceeding which I had challenged on the basis of my psychiatric illness
Okay.
to take, my lord.
Okay, list on today is 22nd, no? 1, 2. On the 6th step. Okay.
My lord, could it be after the 11th?
Okay, 11th.
11th. Pleasure.
So far the bank is.
Mr. Chaudhary, for whose matter?
My lord, item 29.
This will take
Unlike-
some time. No, it'll reach. One side is already over and it's not taking too much of a time. But you can come after half an hour if you are very keen to do the case.
In that case, my lord.
Long weekend is there.
Yes. That case, can you have it?
You should not be an obstruction.
First week of September.
Okay, we'll not. First week of September. Kuntu asile? Item number? 29 may not reach also.
Not next week, my lord. 30th of.
29 may not reach also.
Yes,
What is the matter about?
it's a service matter.
Hearing matter 24, why?
My lord,
2024 matter.
I think, my lord, we express our urgency, that is how. Because my promotion has been held up on the same charge, my lord, a DP and a criminal charges are there, criminal proceeding.
We'll have some other day.
Yes,
On
our only
request.
urgency is, my lord, my promotion to IS is
Okay.
involved, that's why.
Okay.
First week, my lord.
On request, list matter is adjourned to be listed on first week of September. Okay.
May I pray for a 3rd or 5th, my lord, any days?
3rd or 5th. Let me first week of September. Let us.
My lord. Keep them.
Yes.
Because so far, bank is concerned, the final appellate order, that is the at page 132, Lordship, Annexure 25.
Yes.
It has given, it had one considerate view. Consideration is that not because of that dereliction of not registering the mobile phone while taking mobile banking service, but his first or previous service was considered. Otherwise, he had no blemish earlier. That is there. That is the reason why the order of the disciplinary authority has been modified. To the extent that this reduction in lower rank to a lower stage in the time scale of pay by one stage for 1 year. That has already left. That is one aspect, Lordship. So far, the officer will not earn increments to pay during period of such reduction, and on the expiry of such period, Lordship, the reduction will not have the effect. That
He
is
gets
there.
back everything. He gets back everything.
Order was perhaps recent order in view of the fact that 1.2 lakhs.
But that is not connected.
He is not connected.
1.2 lakh,
but-
somebody misuses an
because-
ATM
because-
card. It is not under his custody.
That is true, Lordship. That is true. But
And
the-
only because it is involved with that account from which the money has gone, money has been debited. So
only
you are trying to.
one defect is found that he has not actually destroyed or deactivated the.
But was he with the vested with the powers to destroy, or was it the powers of the branch
Deactivate.
manager?
Deactivate.
No, deactivating powers was vested with the petitioner or the branch manager.
Lordship, at that point of time.
He was not the branch manager. See, somebody had adopted an unfair and fraudulent means.
Because of
Fraudulent means by somebody else. If you implicate him or punish him, he has to be a
fraud,
part of
so
the.
far fraud is concerned, he is not
He is not
directly
connected.
involved. But it is the consequence of the attack, perhaps. That is the reason.
No,
Really,
not only extracting the ATM, he has to know the PIN number.
so
it's
many
a-
things are
so many things are there.
That is there. But
And his father has returned back the money. Returning is not a very important consideration if he was involved. Returning of a misappropriated amount, that is not something to be excused. But he is not involved at all.
his involvement, of course.
What are the penalties you otherwise you have in your prescription?
That he has
What are
already-
the rules?
Whatever is there, Lordship, he has already under.
Rules, regulations?
Next, Lordship.
Service rules
it was-
we said.
No, we are asking about a regulation, service regulation.
Yes, officer, as section 77,
No, no,
67.
It happened we said.
Oh, it up. That is not with me at this moment.
Can you read out the prescription of the penalties? What are the penalties? Do you have, Mr. Bhumik? Mr. Kandilia?
Right now,
Right now, I don't have. I can produce.
No,
I can also do this thing.
no, there would be a minor penalty like censure or something,
Yes, yes.
giving him a warning or
Yes,
asking him to become more, be more cautious.
yes.
But I don't think this is a matter where he should impose penalty.
Yes.
And as you have also pointed out, that his previous history does not
Yes,
show
this is what is the main
that he
consideration.
was involved in any such activities.
If your lordship takes it up after half an hour, I can.
Asani Ketu, SBI Hiritu,
State Bank of India Officer Service Regulation.
Yes, sir.
I don't think it will be available.
It-
Online it may be there.
Online it should be, it will be there.
I have a printout.
Yes, sir.
Asana?
Officer Service Regulation. Service Regulation.
Service regulations.
Rules will.
Regulations along with rules. So, act minute. Officer Service Rule.
Yeah. 67.
Here to silent. Here to silent. Here.
গোটেইখিনি নালাগে নালাগে গোটেই সেকশন ৰুল 67 চোৱাচোন
penalties which can be imposed.
Rule 67. Penalties prescribed বলে আছে নাকি? কি কয়? Heading to কি? 67. Penalties. No, সেইখন page
So
দিদি।
far, so far, Lordship, this 67 F is concerned, it falls under the major penalty. But the penalty imposed as per the appellate authority is the minor penalty in a sense. It is 67 E, which may not be extended, exceed 3 years. So apart from this censure, your Lordship has already mentioned, withholding increments with or without cumulative effect,
That they have
withholding
done.
promotion. So Lordship, 67 B. Without cumulative effect.
This was without cumulative effect.
Yeah.
Initially by the
It was with cumulative, later on
disciplinary authority, it was with cumulative effect, but
Yeah.
later on it was changed.
it was modified.
Then sure.
Censure. Minor penalty.
And here, if you go very technically, you have imposed two penalties. You have reduced him to a lower stage in the time scale.
Yeah.
I have also withheld the increments.
Increment.
These are separate penalties.
Without withholding the increment, Lordship perhaps may serve the purpose. Because the penalty imposed is
Penalty has, you have imposed two penalties. You have withheld his increments, you have reduced him to a lower stage.
And at that relevant point of time, because of this, he was not considered for promotion also.
What is your age now? Age?
He's in his late 40s, early 50s. It will have a cascading effect, already had on his career.
What are these, Mr. Taludar? এখন কি আছিল এখন হেৰিত নালাগে এইখন তাতে দিলে হয়। এই যে আৰ মজুমদাৰে যে তিনিটা কেছ আছিল যে হস্পিটেলত থকা বুলি কৈছে what are these records?
these records are regarding disciplinary proceeding, Lordship. Because the record before your Lordship was earlier considered as not decipherable. But the summary record is already there before your Lordship. In view of our last order, Lordship, the record has been submitted. Same, summarily same.
What can be done? Tell us.
Perhaps 67B, so for minor penalties are concerned without cumulative effect. That is my humble submission. Of course,
And that has already been given. That has already been given.
That has already,
Reduction
he has
to
already
lower
suffered whatever, in that 1 year time has already been elapsed long back.
You remove that reduction of lower stage increment part had become redundant. Lower stage will have an effect in his career also. Okay.
As your lordship, a punishment of censure would have served the purpose.
No, this withholding or increment,
Hmm.
that was without cumulative effect.
Hmm.
That will not have any, as on today. it will
As
not
on
have
date,
any-
it does not have any.
It has no
At that
meaning.
time, it had.
It has no meaning.
They ought to have awarded a punishment of censure. It is quite disproportionate, I think, the punishment imposed, considering the gravity of offense.
No, this was of 2013,
Yes.
and that 2 years is over long back.
Lordship will observe that this will not have any effect on his future career prospects.
No, if that a penalty is there, they might take into consideration.
But Lordship, that is my anxiety, Lord. And at that time, Lordship will consider
Even
the
a
fact,
censure is there, then also to take into consideration.
Lordship will see the system allowed it. In fact, in my affidavit in reply, I have annexed the international banking norms, which the State Bank ought to have adopted. Those are Basel norms, named after a European town. They have ought to have adopted that system, which they have not done. And because of that,
Okay.
junior officer, an officer in the lowest rung of administration, ought not to suffer, your lordship. That, I humbly submit, leads to travesty of justice. The Basel norms I have annexed along with my petition, lordship.
लिखा ना, दे दीजिए ना.
While introducing mobile banking, State Bank has gone by the process of trial and error.
Okay, let us pass the order. The instant petition has been instituted under Article 226 of the Constitution of India, challenging an order dated 30/8/2013, passed by the Appellate Authority of the respondent State Bank of India, whereby the penalty of, within inverted comma, reduction to so and so has been imposed. Full stop. The initial penalty imposed by the Disciplinary Authority dated 25/3/2023 was slightly modified by the Appellate Authority via the aforesaid order dated 30/8/2013. Full stop. Para. Para no. The challenge is based on the aspect that there was no substantial charge against the petitioner, and there was no evidence at all to implicate him with the charges. Para. As per the facts projected, comma, the petitioner at the relevant point of time was serving as the assistant manager of the respondent bank and was posted at the Titapur branch. Full stop. While in service, comma, a show cause notice was issued to him on 21/6/2012 with 4 numbers of allegations. Full stop. The petitioner replied to the same, and being unsatisfied, comma, an inquiry was initiated. Full stop. The amongst the 4 charges, comma, the inquiry officer came to a finding that charges numbers, charge numbers. Where is the chart?
Annexure 1293, 91, Lordship. Allegation 1, 2 not proved,
Uh,
3 and 4.
where the charge numbers 1 and 2 were held to be not proved, and charge numbers 3 and 4 were held to be proved. Full stop. The disciplinary authority had, however, disagreed with the findings in allegation number 1 and 2 and had accordingly issued a notice to the petitioner on 23/1/2013. Full stop. The same was replied to by the petitioner, whereby he had stated that there was no reason to disagree with the findings so far as allegation numbers 1 and 2 are concerned. Full stop. It was also stated that the findings of the inquiry officer so far as allegation numbers 3 and 4 are concerned are not based on any evidence on record. Full stop. Nonetheless, wide the initial order of penalty dated 25/3/2013, the disciplinary authority had imposed the penalty of so and so, At page 19, 119, all out in here for eligible. The aforesaid order was put to challenge in a departmental appeal, and the appellate authority vied the order dated 30/8/2013 had, however, interfered with the penalty and had modified the same in the manner indicated above. Full stop. The appellate authority, however, did not exonerate the petitioner. Full stop. The petitioner had thereafter submitted a review, which, however, was rejected vide an order dated 19/7/2014. Full stop. It is the legality and correctness of the order of imposition of penalty which is the subject matter of challenge in this petition, as indicated above. Para. I have heard Sri P. Bhomik, learned counsel for the petitioner. I have also heard Sri L. Talukdar, learned counsel for the respondent bank, who has also produced the records of the disciplinary proceeding in 2 volumes. Full stop. Para. Sri Bhomik, the learned counsel for the petitioner, has submitted that though there are 4 numbers of charges, the charge numbers 2 and 4 are related to the charge numbers 1 and 3. Full stop. It is submitted that the first charge is with regard to non-verification of a mobile number of a customer who had availed the facility of mobile banking service. Full stop. He has submitted that admittedly one generator operator involved with the branch was given the task of facilitating the customers to avail the said facility of mobile banking service, and at that time, there was no requirement to have the same mobile number in the form submitted, full stop. In any case, it is the version of the petitioner that he neither had the expertise nor was authorized, nor was tasked, the SKED, to verify the mobile number, full stop.
Lordship, he was neither trained. He was not trained. It is Malin Pegu who was trained.
And such verification was entrusted to another personnel who was trained for this purpose. Full stop. He accordingly submits that the first charge with which the second charge is intrinsically connected cannot be a charge at all, so far as the petitioner is concerned. Full stop. As regards the third charge, which is of serious nature, amounting to defalcation of an amount of rupees 1,20,000 of one customer by misuse of a surrendered ATM card, it transpired that the same was done by the same generator operator who was entrusted with the task of facilitating mobile banking service. Full stop. It is also on record that the father of the said computer generator operator had returned the money. Full stop. It is the specific case of the petitioner that the surrendered ATM card was not in his custody and was rather in the custody of the branch manager. And he did not have any role whatsoever in the said fraudulent activity. Full stop. It is also averred that the question of negligence will not arise since the petitioner was not the custodian as noted above. Full stop. The learned counsel submits that in view of the aforesaid facts and circumstances, the findings arrived at by the enquiry officer that two of the charges were proved itself is a perverse finding. Full stop. The learned counsel has submitted that the petitioner had explored the option of preferring departmental appeal, in which though the penalty was reduced, there was no exoneration, and the consequent review has also been dismissed, also been rejected on 19/7/2014. Full stop. The learned counsel has submitted that under the so-and-so rules, penalties have been prescribed in Rule 67, which includes lesser penalty, includes the minor penalties, including censure. Full stop. However, without exploring the said the same, comma, the impugned penalty has been imposed, which is shockingly disproportionate, which is otherwise also shockingly disproportionate. Para. Sri Talukdar, the learned counsel for the respondent bank, has however submitted that there is no grounds of challenge so far as the safeguards given to the delinquent petitioner is concerned. Full stop. He submits that that all the procedures laid down have been meticulously followed, and the petitioner was given all the opportunities to safeguard his interest. Full stop. He submits that in the departmental inquiry, comma, the management had adduced evidence through 5 numbers of witness. How many witnesses? Through 4 numbers of witnesses, and the petitioner was given the assistance of a defense representative,
Yes,
who had also cross-examined the witnesses. Full stop. It is submitted that the findings arrived at by the inquiry officer was reasonable, inasmuch as out of the 4 numbers of charges, comma, charge numbers 1 and 2 were held to be not proved, which itself shows that the inquiry officer had proceeded in an unbiased manner. Para. The learned counsel has also submitted that, taking into consideration the unblemished service record of the petitioner, comma, the appellate authority had reduced the penalty, and therefore there is hardly any scope for further interference by this court. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court, including the records of the disciplinary proceeding, have been carefully perused. Para. Though this court, in exercise of powers under Article 226 of the Constitution of India, plays a secondary role and would not venture into the aspect of reassessing the evidence on record, comma, since the principal ground of challenge is that there is no material and evidence to substantiate this charge, comma, this court has had a cursory glance into the nature of the charges vis-a-vis the evidence on record. Full stop. The first charge is with regard to registering a mobile number of a customer who had applied for mobile banking service. Full stop. The charge is that an incorrect charge is that a different number was registered without checking the telephone number of the customer involved. Full stop. This court has seen that the aspect of mobile banking service was at a nascent stage, and certain personnel were given training to enable the customers to avail such facility. And amongst those personnel, comma, there were two persons, full stop. The petitioner, who was an assistant manager, was not entrusted with the verification process, full stop. Though the charge is that a different mobile number was put in the concerned application, comma, it is also the submission of the petitioner that at that point of time, comma, it was not necessary to have the only one mobile number in the application, full stop. The allegation number, the second allegation is intrinsically connected with the first allegation that the mobile banking service can be done in the home branch only, and in that manner negligence has been attributed to the petitioner, full stop. The allegation number 3 and 4, though serious in nature, as it involves defalcation of defalcation of an amount of rupees 1,20,000 of a customer by misuse of a surrendered ATM card, comma, the allegation against the petitioner, the allegation so far as the petitioner is concerned, is only being negligent in not destroying the surrendered ATM card, full stop. There is no allegation that the petitioner was involved at all in the fraudulent activity, full stop. The submission made on behalf of the petitioner is that he was neither the custodian of the surrendered mobile card, nor was he aware of any such fraudulent activity, full stop. It is submitted that the petitioner was only the assistant manager, and it is the branch manager who is the custodian of ATM cards, and any activities of destroying such cards on its surrendered is vested with the powers and vested upon the branch manager, full stop. The allegation number 4, as noted above, is not of immediately deactivating or destroying the ATM card, and the effort and the discussion made above would also cover the allegation, cover this allegation, full stop. Though, no, para. A look, a perusal of the disciplinary of the inquiry proceeding would also show that the customer in question, whose mobile number had deferred, would also show that there was no apparent mismatch of the specimen signature of the customer in question, whose mobile number had deferred. And it is only in the context of such specimen signature wherein the involvement of the petitioner would come, as he was the assistant manager, full stop. It is also on record that on that particular date, comma, the petitioner was alone handling all the activities of the branch, and therefore the action taken by the petitioner has been termed to be bona fide, full stop. The charge which have been discussed above are trivial in nature, full stop. As noted, comma, the charge numbers 3 and 4 cannot be attributed to the petitioner, as the allegation of misappropriation is admittedly not against the petitioner, and the charge is only of being negligent in not destroying the ATM card and is not destroying the surrendered ATM card of one of the customer, full stop. This court has also already noted the defense of the petitioner that he was not the custodian of the surrendered ATM card, full stop. So far as the allegation numbers 1 and 2 are concerned of not verifying a mobile number in the form of a customer who had applied for mobile banking service, comma, the said allegation is allegation, comma, even on its face value would be a trivial, is of trivial nature, which for which imposition of the penalty in question appears to be disproportionate and harsh, full stop. The appellate authority, while examining the appeal of the petitioner, had taken into consideration the past service record of the petitioner and had reduced the penalty in the manner indicated above, full stop. Para. So far as the penalty is concerned, comma, Rule 67 lays down the penalties which can be imposed on after imposed in a disciplinary proceeding, full stop. Withholding of increment of pay with or without cumulative effect is a distinctive is a separate penalty which is under 67B, and recovery and reduction to a lower stage of in time scale of pay for a period without cumulative effect is a separate penalty under 67E, full stop. It appears that by the impugned order of penalty, comma, impugned order, comma, 2 penalties have been imposed upon the petitioner, full stop. The appellate authority, while interfering with the original order of penalty dated 25/3/2013, has removed the aspect of cumulative effect so far as the withholding of increments is concerned, full stop. The penalty being of the year 2013, comma, as on today, the same has spent its force, full stop. However, comma, the aspect concerning reduction to a lower stage in the time scale of pay by 1 stage for 1 year would have a cascading effect, full stop. Under the facts and circumstances aforesaid and the discussions made, comma, this court is of the opinion that the penalty imposed be restricted only to withholding of increments for the period in question without cumulative effect, and the first part of the penalty of reduction to lower stage in the time scale of pay by 1 stage for 1 year would stands interfered with, full stop. Consequently, comma, it is directed that the proper fitment be given to the petitioner in his present posting, and he should not be denied, and the same would not have any adverse effect so far as future service benefits are concerned. Writ petition stands disposed of, stands allowed in the manner indicated above. Original records are handed back to the learned counsel. Monday. We'll give it on Monday. Just check. Yes.
Okay, 4 weeks time is sought for filing the affidavit.
Okay. Last time I think we had granted you time.
Yes.
But you have got the instructions. Why do you need 4 weeks? We had given it 2 weeks time. Okay, order prayer made on behalf of the department. Further 3 weeks time is granted.
Yes.
To file the affidavit of opposition. File it.
Obliged.
This is item number 7.
Yeah, please, the Lordship. My lord, today's stick for production of records. My lord.
We have not yet received the record, Lordship, so some more time is required.
Record of
The interview held, my lord, all the candidates.
regarding.
Regarding, my lord, laboratory technician,
Okay. Okay, get the records, madam.
Lord,
It will come from where?
page 4 medical.
short date maybe, my lord.
Okay. On the prayer of Ms. D. Bora, Learned Standing Council, Health and Family Welfare Department, matter is adjourned by further 2 weeks to enable her to obtain the records of the selection.
My lord, first week of September, if possible, my lord.
List in the first week of September.
Okay.
My lord, can it be on 5th instead of 5th of September?
No, we have said first week of September.
This is first week of September. Hearing that it was, my lord, 5th if possible.
It will come, don't worry. 23 matter. Today is what, 22nd? 2 weeks.
Fifth of-
2 weeks now. Let it be on 9th of September.
My lord, instead, my lord, then my lord, 10th of September,
11th.
11th. Oblige me, lord.
Yes, what is this?
Your Lordship, this is a challenge to the disciplinary proceeding
I for
for vacation of the interim order.
who's for the Union of India?
Mr. Chakravarti, I just told my colleague to call him. Lordship, otherwise pleadings are complete and Lordship, otherwise the petitioner, he has been subjected to this particular disciplinary proceeding even after a judgment which has fell down from your Lordship, wherein your Lordship had directed to issue the NOC to join a particular organization.
In this case, deliberation will be required. Lordship, the movement will be necessary because in the sense, after he is having been released, whether we can continue the DP or that aspect has to be seen.
Last occasion also, he took time, your Lordship, on this ground only.
He has joined there. What's some for
No,
him?
Your Lordship.
What's some for him? We have released him.
No.
He has
Then-
went there and joined.
Then
Yes.
very well, this the DP may be.
Now he
dropped,
has
Your
been
Lordship.
challenged the DP whether that will be without hearing us.
Now DP has culminated into a penalty or what?
No, Your
No, we just issued the charge sheet.
There's an interim order, I think.
There is an interim order.
Lordship, there is an interim order, but since he has now joined this particular new organization, since because of this DP, he has been only allowed to provisionally join, and he has not been paid his salary for the last 3 months. That is the issue.
Unless
Paid-
you're,
paid
unless
the
you're,
paid
not-
salary.
what's the charge?
Not BRO, Your Lordship.
Pay these salaries, why don't you pay the
Not
salary?
BRO, now ICR, he has joined in ICR. ICR is not a party to this particular.
His party, RCR is a party here. Party to the writ petition. He himself has made a party.
No. Wait.
No,
Unable to be
this is
educated.
recorded.
Who is representing ICAR?
I said, Mrs. R.B. Bora. Mrs. R.B. Bora. Rita Bora. But they are not a necessary party, Your Lordship. Here, what has happened? If I
No,
may
if you have
just-
not received the salaries from ICAR, we'll direct them to receive. Because see, pendency should not be an impediment for you to discharge your duties.
Respondent number
There may be
7.
some, for exigency, some delay may be there.
But if I may state, Your Lordship, if I may just state, if Your Lordship may kindly peruse to the judgment, which is at page number 65, wherein in terms of the judgment, NOC was directed to be issued by the VRO, so that I can join the ICR.
No, you have joined there.
Yes, I have joined that and they have issued NOC also. The main purpose of the NOC is that no objection. Now the whole thing that permeates from this NOC is that this particular charge sheet is still alive. The charge memo is still alive. So until and unless that is quashed, Your Lordship, he is facing harassment there in ICI. They have
What kind
just
of
allowed him-
harassment?
They have allowed him to join provisionally. That is the issue, Your Lordship.
You need time for what, Mr. Chakraborty?
Lordship to make some preparation on the whether we can continue the DP or that aspect has to be dealt with.
On last occasion, they took time on this ground.
relief he has got, Lordship.
Okay, on the prayer of Sri B. Sri B. Chakraborty, learned CGC, prays for some time to obtain further instructions. Full stop. List when?
Next week.
List. On 10th of September, Tuesday,
Lordship.
10th of September. Interim order passed earlier to continue till the next date of listing. Yes.
My lord, in terms of the last order, my lord, we have, my lord, released the arrears of the provisional pension. My lord has directed, till the time the calculations are made, my lord has directed to release, my lord, so we have done it, my lord.
There is the last order.
Yes, we remember.
Yes,
Everything was stopped. Now,
everything was stopped.
now you have got the provisional pension.
Yes, they have used it for 6 months and they, in terms of the letter lordship, they will be again releasing after 6 months. So, but lordship, regarding the calculation part, they have not mentioned anything. That page 37 of the writ appeals order clearly states that make the calculation and do the needful.
Okay, let them work out.
Yes.
Mr. Gupta, work
No,
out.
that observation may be made, my lord, that's necessary deductions. That may be allowed to be made.
How deductions will be there?
No, my lord, I will just submit, my lord.
Now, where is the aspect of deduction? He comes to the court for deduction.
No, my lord, the amount which he has earlier received and the amount which subsequent to the order passed by the learned single judgment, the calculations, now we have done the calculations, there is some amount which the incumbent is liable to pay to the
Why
department.
should he come to the court to have a reduced pension?
No, my lord, my lord, we have.
How can it be reduced?
My lord.
See, you are paying him 10.
My-
He comes to the court, he says that we are entitled to 20. Now court says that you pay him 20. So where is the question of deduction?
My lord,
He is saying lordship that since I have been already granted pension, that was not superannuation pension, that was the premature pension that I was receiving since 2008. So
You
calculation.
adjust.
Yes,
Adjust. He is agreeable to adjustment.
my lord.
Yes, lordship, that we are.
Heard 3H, Tawil, the learned counsel for
AR Tawil.
AR Tawil, the learned counsel for the petitioner in these cases. Full stop. Para also heard Sri H. Gupta, learned CGC. Para. The learned CGC has placed on record a communication dated 2024, whereby the provisional pension has been released. Full stop. The Tawilda, the learned counsel for the petitioners, has also acknowledged the same. Para. Let further exercise be done and completed for adjustment of the amount from those earlier paid to the petitioner?
Yeah. Let them first calculate. First calculate, then let me
Uh,
by way of affidavit. Adjustment.
For key completion.
That adjustment now, that should not
No,
be.
no, উপরে তো। No. No, that's not উপরে। To compute.
Yes, sir.
To compute the amount which is payable to the petitioner.
Yes, thereafter.
Full stop. After such calculation, comma, further orders will be passed.
Yes.
To orders will be passed, which would include the aspect of adjustment.
That,
List after 4 weeks.
oblige.
Please, your lordship. Also, my signature was cleared from court number 7. I have to pass.
What is your prayer? What do you need? What is your prayer? Passing over for time being?
Yes.
At 3 o'clock.
After
See, this matter was listed at your instance. 28th it was there, then you said 22. In 2 days it was listed. Then you're not here. Either you argue or we'll adjourn the matter. A prayer for adjournment has been made on behalf of the petitioner.
lordship, interim is there.
List on Wednesday next. Para interim order. Stand extended till the next date of listing. What is the matter, ma'am Talura?
Lordship, it's pertaining their selection for promotion.
Okay, Wednesday.
One post has been kept vacant for that. Yes.
The matter is just non-granting of promotion. But for the last 3 occasions, no affidavit has been filed, so prayer will made after it. It's the 4th time. They're seeing it.
Yes,
Sometime maybe that, but
okay. You filed the affidavit, with not granting a promotion for what?
They are saying that because of LMC, the petitioner is in low medical category, but there is a provision that even low medical category persons are also
Not
entitled.
4th time, Mr. Tabilder. It was notice was issued on 11/3.
11 people.
Then it came up on 5/6.
6-5.
5/6. Taken time, and the next you had sought adjournment.
Okay.
The last occasion you had sought adjournment.
No, Lord.
Yes, 29/7. Adjournment was sought for on behalf of Mr. Yard Tahvildar. You are not there.
Plus one. Yes.
One occasion only. Let them file.
No, Lord.
Yes, how much time, madam?
if possible, please.
You filed it within 3 weeks. Okay. On a prayer made on behalf of Miss A. Gayan.
Yes.
Learned CGC. Matter is adjourned by 3 weeks to enable filing of affidavit in opposition.
Oblige.
Lordship, 4 weeks time is for filing the affidavit.
Okay. On a prayer made on behalf of the Panchayat and Rural Development Department, matter is adjourned by 4 weeks to enable filing of affidavit in opposition. What is the matter, Mr. Islam?
My lord, matter relating to the non-payment of higher pension, my lord.
What is your, how have you based your?
My lord, it is already, issue has already settled by the division bench as well as other coordinators.
Okay.
Matter issue is already.
You look into
settled.
this aspect, it is settled, then no point.
My lord, kindly see the, my lord,
Okay, well,
some short date.
4 weeks, they have let them file. 24 matter. Highly obliged, Lordship. Yes.
May I please, your lordship? This case is regarding payment of family pension.
Family pension. একটু এসিটা বন্ধ করে রেখেছে 10 মিনিট পিছু। Yes.
Then my husband was initially appointed as a master worker on 17/9/1981. Subsequently, he was upgraded to work as proceeding on 8/8/96. And since the day of his upgradation as proceeding, he was paid regular scale of according to ROP rule. And he was also a member of DPF. Ultimately, he died.
He was member of
DPF.
Okay.
Subsequently, he died on 2/11/2011. After, in that way, he has completed altogether 30 years of service, including 15 years of work experience. So, I applied for.
Now, where was your service regularized?
Formal, there is no formal order of it. But actually, in 2005, there is a government order, government decision to regularize workers and master worker who joined for 1/4/93. In that respect, he was entitled for regularization, but somehow his name was not appeared in the list, and subsequently his name was sent to the government for regularization. That is in page 29. Page 20. 26.
Yes.
But in the meanwhile, he died, and no regulation, formal regulation order was. But Miller, he was working against the sanction force. So our prayer is that family pension may be granted if necessary to extend his benefit. If necessary, the service of my late husband may be regularized for the cost.
That law has changed after Upendas.
No, Upenda's case is not relevant to our case.
Why?
Upenda's case is mere for temporary worker, not against who working against sanction post.
Temporary Upendas is not only for temporary workers. There are three kinds of work. Kindly read. Kindly read paragraph 22. 22? What are the three sections? There are three kinds of.
Upenda's case is mainly for temporary who are not working against sanction post. But my husband was working against sanction post.
Now, if you say sanction post, then immediately we'll say whether he was inducted in the sanction post by a process of law. You will not be able to answer. Why do you go to the aspect of sanction post?
Sanction post, well, that may be,
No, Uma Devi says 3 grounds.
Yeah.
3 grounds. You are only saying 1 sanction post. And from where are you saying that it's a sanction post? From where is the document to show it's a sanction post?
sanction post is record will state it. DPF is only against sanction. DPS is
But without an order of being regularization,
and the copy of the service to your lot to kindly see. this service-
page,
service- service
page,
law.
page.
Page, page 32.
32.
Relevant is 35 without,
32. 35.
this scale has been revised time to time. Then there is a provision that after 12 years of continuous service, if a party, say employee is not promoted, then he get his great action to be enhanced.
Stagnation benefit.
Yeah.
Yes, what do you say, Mr. Naik?
Everything
Mr.
is
Dhar?
there. So from unless it's a sanction post, his benefit would have been, he will not be allowed. And DPF granted only for the against sanction post.
When did the husband die? In 2011.
Yes,
2011.
Yes.
You filed this in 17. You filed this petition 2017.
Yes. Yeah, approach the authority time to time, but
Yes, what do you say? Who will respond?
Okay. Sanctioned posts or not, that is a different issue. But as it appears, CPF account was open. Yes. But if CPF account is open against his name, then what is the necessary for praying for regularization? Having a GPF account,
No, they are not getting the family pension.
then that is why Lordship kindly see page 35. Page 24, sorry, page 24.
24. Yes.
Is the letter to the Accountant General Lordship by the executive engineer. Here he has been clearly mentioned as a work search employee. With reference to the above subject, I have the honor forward herewith the application submitted by Srimati Gita Burma, wife of so-and-so, ex-work search Chokidar, along with the following documents. Final withdrawal of her husband's CPF amount accumulated in account for favor of your kind disposal.
Now, what does this indicate?
He was against a boxer's force, though. But against the person holding a boxer's force can also be allowed to open his GPF account. That is a different deposit in the GPF account.
private sector not CPF.
Even private sectors are allowed.
That's all CPF.
They can contribute.
But here the basic issue is without being regularization of his service lordship, whether his wife can claim for family pension or not. That is the main issue. And here lordship,
But look at his service book. See the sequence in the service book. Annual increment, scale payment.
this is not service book. In fact, lordship, this is service role,
Huh? No,
page 32.
32 on, huh?
Page 32, lordship, kindly see the first claim. Petitioner's husband, Walker's survivor.
Now, whatever nomenclature you have used, kindly turn over the page and see. It's exactly the same as service book.
In several cases, Pilot, government has already allowed this benefit. After it, page, it, page 50.
GPF, can anybody open? It's GPF. No, not provident, GPF. Not
General
any other provident, general. Can it be opened?
I'm fully aware that even private sector employees are also
That is contributory.
having that. Even the journalists can also open a
That is contributory.
Private sector very complete. That is as per the private.
notification.
You
PF
can,
is allowed only for
any
regular.
person, private person can go for PPF, that's a different public provident fund, contributory provident fund.
That issue, we can clarify a lot. That we can.
Because normally, see, it's very easy to say Upendas is applicable, no order of regularization. But here, the documents which he has annexed, grant of skill, increments.
No, workers employees keep I mean, here, just like government employees, they keep they get increments also, they get normal scale pay, everything is same, but their posts are not regular. That is down. Otherwise,
And initial entry was in 1981.
that is master.
Master roll.
Subsequently,
96.
since 96, he is working as a worker. And while working as worker, he was getting skill pay lot. Even the workers employee also entitled to increment also.
Have you filed affidavit?
Affidavit PW has filed.
Yes, Mr. Dhar, what do you say? PTC, who is for
Kindly
PTC?
see one affidavit filed by one Srimati Nirmala Mati Vaishnav, that is AG. Dear Lordship, one paragraph 5 is there.
AG's affidavit.
Yes. And another affidavit filed by the executive engineer PWC.
In AG's affidavit, which page?
Paragraph 4 is there.
Para 4.
I mean, paragraph 5, Lord.
Hi, please read.
That is regarding GPF.
Please read.
That with regard to the statement made in paragraph 6 of the petition, it is replied that in terms of letter forwarded by the executive engineer PWC Kokrada Division by letter number 26/12/2012, along with GPF application form number C and other documents in respect of husband of the petitioner, the GPF final payment authority has been issued against his GPF account number so and so amounting to rupees 1,12,245 addressed to the Kokrada Treasury Corp. But that has been accepted.
See, AG's stand will not be relevant. It is ultimately the administrative department.
Yes, PWC Lordship, next one affidavit by the concerned executive engineer Lordship.
R4.
R4 Lord.
Yes.
Rahul Dev Pachmatati. Lordship, here there is mention about sending his name for regularization, but nowhere it has been stated that his service has actually been regularized. Paragraph 6 Lordship. The deponent begs to state that the left out of regularization of workers and master labor under this division sent to the higher authority on 3/6/2006. So he has not been regularized. In fact, one attempt was there even after 2005 also for regularization of the left out worker. And to that effect, Lordship, one IA was filed before the division bench of this honorable court seeking leave for consideration of their regularization. But that was rejected by the division.
Mr. Das, the department says that it was sent for regularization, it was not done. And if it is not done, it will be difficult.
There is a, our court also has passed order which says 58.
58. Yes.
Relevant is 61. But in this case, the similar case allow.
No, the entire concept has changed after Upendas.
Lordship, even
No,
under
Upendas is not covered by case. Upendas is only for temporary worker, not
Please,
against.
please show Upendas.
Yes, Upendas case.
It is for those employees whose regularization was left out.
Dr. Upendas is all about employees engaged prior to 3rd March 1993.
Yes.
And it was held by the Honorable Court. No order can be passed for their regularization and allowing them
No,
consequent
Mr.
benefits
Das
like
is
pension.
time again saying it's not for them. Kindly see the expressions used in Upandas. 3 expressions used. Mr. Dhar, you have Upandas? Please show it to Mr. Das.
Yes, yes.
Please read here. Please read.
Last page. It is, however,
Heartening.
heartening to learn that the state government has agreed not to terminate the master elder or officer.
See,
Similarly, this
you are
employee
saying there is no work charge.
for since last
It is
10
three expressions. The time and again we are reading Upendas.
But yeah, last time you were also kindly see. Yeah, there is, it is very clearly mentioned, not in section 4.
Yes, because this was rendered after considering Uma Devi, paragraph 53.
As per Uma Devi's case also can be guaranteed. I am relying on one Supreme Court case.
Prem Singh has been taken into consideration in subsequent cases also. Which
Right.
paragraph?
Paragraph 35, last page. Paragraph 30.
35.
Internal to space 2.
Here the case facts were different. Others were given the benefit of regularization. He was left out. And this court, in this decision, only one aspect of Uma Devi has been taken into consideration. That working for 10 years without any cover of the court as an one-time measure. There are two other aspects. How can you ignore the other aspects?
I am working for more than 30 years.
Lordship,
That is not
just
the only aspect.
distinguishing Judge Prem Singh, Lordship, one judgment I can cite, Lordship, AR 2023, Supreme Court 2971. One specific paragraph is there. The decision of this court in the case of Prem Singh, therefore, would be restricted to the counting of service rendered and workers for qualifying service for pension.
Yes, that is
No
not the
other
only
issue.
concern, no others.
On the issue there,
There will be no doubt that we have just only the length of service has been taken into account,
Yes.
nothing else. Uma Devi has other aspects also.
And in that judgment also, Lordship Prem Singh, in the previous paragraph, three conditions of one DB was taken note of. But ultimately, when the direction was issued, only two conditions were taken note of. One condition remained.
Which is the second, this case we cited?
This is Lordship AR 2023 SC 2971. Lordship, kindly note the parties. Uday Pratap Thakur and another. Uday Pratap Thakur and another versus the state of Bihar and others. Justice MR. Separate petitions were there. I'm relying upon paragraph 6.3, last 4 lines.
But the aspect of GPF remains.
Oh.
But at the same time, you have shown two of the paragraphs in the affidavit that it was indeed sent but not regularized.
Okay. But that aspect of non-regularization is the fact, Lordship. Lordship, holding that his service was not regularized, I would like to rely upon 4 judges, Lordship. First one is, Lordship, 2008 to SCC 310. This one, this is the mark.
2008?
2008 to SCC 310. Paragraph 16, Lordship.
Para 16.
Para 16, Lordship.
Yes.
Lordship, here in paragraph 10, Lordship will see the pension release same to that of us, Lordship. Paragraph 10, the first 3 conditions, Rule 31. And paragraph 16 is the direction, Lordship. The conclusion, Lordship. The scheme relating to grant of family pension. Here his basic prayer is for family pension. The scheme relating to grant of family pension was made under a statute. A person would be entitled to the benefit of thereof, subject to the statutory entity, from a bare perusal of the provisions contained in the Punjab Civil Service Rules, Volume 2, vis-a-vis the family pension scheme. It would be evident that the respondent was not entitled to the grant of any family pension. The husband of the respondent was a worksource employee. His service had never been regularized. It may be unfortunate that he had worked for 11 years. He expired before he could be granted the benefit of regularization scheme, but sentiment and sympathy alone cannot be ground for taking a view different from what is permissible in law.
Yes.
Next judgment, Lordship, I am relying upon 2022 SCC online SC 818. It's a short judgment, Lordship. Lordship, here basically, Lordship, the division bench directed. It's a judgment from our High Court, State of Nagaland and others versus Nishebi Asumi. A direction was issued for 1-day regularization and grant family pension to the wife.
Yes.
That was interfered with by the Supreme Court.
Paragraph?
Lordship, entire judgment I'm relying upon. It's a very small judgment. Paragraph 3, Lordship, the issue
Yes.
there. Feeling aggrieved
Yes.
and dissatisfied with the judgment and order passed by the learned single judge, the appellant state had preferred an appeal before the division bench of the High Court. By the impugned judgment and order, the division bench of the High Court has dismissed the state appeal and has not interfered with the judgment and order passed by the learned single judge, regularizing the services of the respondent's husband 1 day prior to his demise. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the division bench of the High Court and not interfering with the judgment and order passed by the learned single judge, state has preferred the present appeal. Though served, nobody appeared on behalf of the respondent, and Lordship may come down to paragraph 7. Paragraph 7. Having heard learned counsel for the state and considering the submissions made on behalf of the state and having gone through the judgment and order passed by the learned single judge, confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the services of the deceased employee 1 day prior to. This is the precondition, Lordship, to claim family pension. The service of the husband has to be regularized. Third judgment I'm relying upon, Lordship, it's WA number 1 of 2022 and WA number 2 of 9 of 2020. Two is appealed. First one by one Ujjala Nardari, UJALA-NARDARY, Ujjala Nardari versus State of Assam. Dear Lordship, the division bench, our division bench, Lordship, dismissed the prayer of the petitioner for family pension whose husband's service was not regularized. Okay.
In this case, my lord, they
One
only-
more judgment,
only
Lordship, I would
consider
like to
they
place.
were not factor.
One more judgment, Lordship. It's 2013 3GLT, sorry, 3GLR 522.
Yes.
State of Assam versus Anjali Thapa. Paragraph 21, I am referring, Lordship. It's a review petition. Initially, a direction was issued for regularizing the service of the husband of the petitioner, Lordship, and found the same for the purpose of paying family pension to the petitioner. Paragraph 21, Lord. Review to ekon type of
Writ appeal.
paragraph 20. That is the writ appeal. This is the paragraph 21.
It is reported.
Yes, sir. DLR.
13.3 GLR.
That is judgment, Lordship, I am relying upon, and my basis is that his service of the husband of the petitioner was not regularized, and in that situation, if he was not in a pensionable establishment, the wife cannot claim family pension in respect of the service of her husband.
Anything you'd like to say?
As per the order of 2005, my lord, they can according to the government policy.
But somehow you are not given, the husband was not regularized.
Yes,
He was
because
left out. Now nothing can be done. Many people got appointed prior to 1/4/1993, got the benefit of regulation. Some were left out. They later on came to the court. Court says something else. Division bench. Policy decision was initially taken. There is no dispute.
due to the mistake of some official, my lord, actually,
But husband passed away when? 2011.
2000.
You came to the court in 2017.
Yes, my lord.
And when did he retire from service?
Retirement,
Died in 13.
died in
He
heart
died in
attack.
harness. Difficult.
There is also
We do not know under what context this was rendered. Please have a look. One paragraph order. Yes, sir. Yes.
38.
Yes.
It has, although not specifically any order has been passed, but on perusal of this order, our division bench once observed that absolutely no reason is. That is not my part, the part of the.
In which case this has been considered?
No, it was no order is there, no pronouncement is there. But in regularization matter, this judgment was placed before the so many occasions. But the division bench never passed any order on the basis of this.
Okay. Likha. Nayak for whom?
I'm referring for finance department.
Finance. And
BTC is also.
BTC and finance.
Since then.
Yeah, for PWD, Sadhar. Nayak for finance and BTC.
Yes.
Barua for AG.
government has granted benefits. That's what is 50, 53, and 58.
50?
Page 50.
This is creation of supernumerary post is has been deprecated in this by the Supreme Court.
In fact, in 2012, itself, the Finance Department issued one notification that no more regularization shall be done and no more creation of supernumerary post.
No, even that Supreme Court in Nagaland case has deprecated
Yes,
this
that
practice.
is there. But in Upendas also, Lordship, the single judge Lordship interfered with that notification of the Finance Department. That was returned, reversed by the division bench.
In Upendas?
Yes.
Which?
2012 notification was.
Where? Which paragraph?
One mention is there. Lordship will get referred to that of that notification of 2012. Open.
Which year the notification was there?
2012, Lord. This paragraph 14, Lord. The respondent also challenged the validity of the office memorandum dated 16/6/2012. In this judgment, Lord, it's paragraph 14. Has not been elaborately discussed, but learned single just interfered with this notification. OM. Lordship, in the same judgment, Lordship may also see paragraph 11. Lordship,
Yes.
here that in one suo motu case being WPC taken up 24/7.
Which case? Umadevi.
Upendra.
Upendra's.
Upendra.
Paragraph?
Paragraph 11.
How does it start?
Lordship, in one suo motu case
No,
being
no,
WPC
not
number
11.
so and so, a division bench
Not
of
11. Not 11.
Lordship. Paragraph 11.
It says one suo motu.
May kindly say that
One-
him today, sir.
Yes, one suo motu. In one suo motu.
Yes, being WPC taken up number 24/7/2007, a division bench of this court was considering the conditions of prison in the state, including engagement of adequate staff and other related issues, and by order dated 37/2010, it directed the state government to frame policy for regularization of casual workers in terms of the full bench decision in the case of Jitendra Kolita. But on 1/11/2010, when the additional advocate general informed the court about the statement made in the case of Ramani Deka regarding consideration of policy to regularize the services of the master workers within 3 months, the division bench observed that no further step needs to be taken pursuant to the direction issued on 37/2010. Then Lordship may kindly come to paragraph 13. One miscase was filed in that suo motu case, Lordship. Paragraph 12 and paragraph 13.
Yes.
Paragraph 12, Lordship, on 14/12/2011, also when the case of Ramandeka was taken up, a statement was made on behalf of the Finance Department that the matter of regularization was under active consideration in coordination with the Departments of Health, PWD, Directorate of Geology and Mining, Water Resources, etc., and the benefit of the deliberation was likely to be positive in favor of the petitioners therein. However, notwithstanding the above statement made before this court, the state government filed MC number so and so in WPC number so and so seeking leave to implement its policy of regularization, and the division bench, having regard to the decision of the Supreme Court in Umadevi case, by order dated 20/2012, declined to grant the leave. Immediately thereafter, Finance Department, Government of Assam issued the office memorandum dated 16/6/2012, stating therein that there shall be no further regularization of service of pastoral workers and similarly placed workers, even if such workers were engaged prior to 1993. The office memorandum dated 16/6/2012 also stated that there would be no more regularization by creating supernumerary posts for 1 day in respect of those pastoral workers who were engaged prior to 1/4/1993 but have died or had attained the age of super.
Civil के लिए बोले बोले hereditary बोले बोले Okay, we'll pass the judgment. We have to just settle the papers.
Right.
We'll pass the judgment. It will be today's date only.
Sure.
We may not be able to give you the relief. एक मिनट. Even they didn't dispose of them. Yes.
May please. I'm appearing in item number 22. My learned friend appears for item number 23.
Okay.
My lord, both the petitioners in both the matters are similarly situated, my lord. Well, the grievance of the petitioners is with regard to the voluntary VRS scheme, my lord. They all were employees of a mill called Assam Cooperative Spinning Mill Limited, Koitamari, which was
Assam?
Assam Cooperative Spinning Mill Limited, Koitamari, which was closed pursuant to its liquidation, my lord.
Okay.
And the designation of the petitioners, my lord, it's called floor level worker trainee, FLWT, floor level worker trainee.
Okay.
Now, my lord, initially when the writ petition was filed, my lord, the petitioners in item number 22.
Okay. Your case.
Yes.
Yes.
They were claiming higher VRS on the basis that they were regular employees. But however, my lord, the cooperative department had calculated their VRS considering them to be casual employees.
Okay.
That was the main issue, that the petitioners claimed that they were regular employees. And the stand of the cooperative department was that
Yes.
they were casual employees. My lord, pursuant to filing the writ petition, the department had filed an affidavit,
Yes.
whereby, my lord, CA firm was given the task to audit and to calculate what is the amount receivable, man.
Okay.
So that was done, my lord. It's part of the affidavit in opposition. And in fact, pursuant to filing of the affidavit in opposition, few of the petitioners had already taken that amount, my lord. And there are only 17 left, my lord. Out of the 44 in 22, 17 petitioners have not taken the amount due to
Yes. Okay.
due to the pendency of the writ petition. My lord, thinking that if this is allowed, they'll be entitled to a higher amount of VRS. But my lord, I've been told by my learned friend, and it is also the instructions of my client, my lord, that since a lot of time has passed and the fund is already available with them, the amount which they have calculated, my lord, as casual employees. So these 17 petitioners, my lord, they are entitled and they are not disputing that. In fact, he has his instructions, it was shown to me. They have calculated that the money is also there, my lord. Now, my lord, I was having a word with my learned friend, my lord, who's appearing for item number 23, and we are all similarly situated. Well, there was another round of litigation in the year 2016.
Okay.
Which is not there in my petition, but in that case, the department was the party and the union belonging to the petitioners that filed the writ petition. In that case, my lords, I have seen from the affidavit, the corporation department themselves have admitted that petitioners in their writ petition, as well as petitioners in my case, they were all regular employees. So, my lord, this is the situation as of now. So I was of the opinion, my lord, I was about to concede and take the amount.
If you are deemed to be a regular employee, then your
The VRS increases.
the amount of the benefit which you'll get on voluntary retirement, that will
Increase.
you'll get a better benefit.
Exactly.
And there is something on record to show that you are treated as regular.
Yes, yes. In fact, an affidavit filed by the department themselves.
Mr. Bodloy?
Otherwise, they are casual employees, they are pro-level employees, and based on the calculations done by the CA fund, the amount has been.
No, what about the other aspect? What
Other
Mr.
aspect-
Mohammed
My
has
lord
just-
takes up the other writ petition. My learned cannot be able to show some record.
Let me kindly page 71 of my writ petition. Item 3. This is the affidavit filed by the
You are
respondent.
3536.
Yes, Lord.
What is your name, madam?
Miss A. Begum,
3536.
71. Annexure 13. Affidavit is filed by the respondent.
71.
Yes, Lordship. This is the affidavit filed by the respondent number 2. This is the Deputy Secretary to the Government of Assam Corporation Department.
Yes.
In para 2, Lordship. That we may I read it.
Yes.
That with regard to the statement made in para 1 of the writ petition, we are humbly deponent of us to know. However, as regard the number of employees of the Assam Cooperative Spinning Mill Limited, it is stated that mill had a strength of 222 employees in total, out of whom 191 were working as regular, and 5 persons have already retired. As many as 18 persons have expired, and the number of casual employees who worked in the mill earlier is 8, Lordship. This is, they have admitted, Lordship. Thereafter, we have sought an RTI application, Lordship. This is in page number 81, Lordship. Kindly peruse, Lordship, page number 80 and 81.
81.
Yes, Lord.
Yes.
Lordship, 81, this is the list prepared by the respondent authority. Proposal is prepared on the basis of equitance rule of spinning mill limited. There are 191 and they prepared 191, Lordship. Kindly peruse page 86. This is the 191 employee of regular employees, and my petitioner's name were included in this list.
Now, how do you say that these are regular employees?
Lordship, thereafter, Lordship, they kindly peruse, Lordship, page number 48, Lordship. This is the proposal. 48, Lordship. It is the type copy, Lordship. Original one is 49, Lordship. 48. It is VRS proposal for the employees of Assam Cooperative Spinning Mills Limited, Poitamari. Nature of employees, regular employees 193, no. And retired and expired employee 21. And casual workers, employees 8 nongs, Lordship. This is the proposal. Lordship, they treat us, my petitioner as casual employee, Lordship. Kindly peruse page number 88, Lordship. List of casual employees. There are 8 number of casual employees, and their names shown. Sri Ansar Ali, Sri Bolen Chandra Roy, Sri Soed Ali Ahmed, Sri Dhananjoy Das, Sri Halimuddin Sheikh, Mrs. Rajabala. This is only 8% they shown as casual employees. Page number 88. This list was provided by the department on RTI application. Yes, Lord.
Now, from where do you infer that you are permanent employees?
They admitted in their affidavit, Lordship.
Where?
Lordship, in page number 71, Lordship. This is the affidavit.
71, where is the admission? 71, paragraph 2, you have, where is the admission?
Lordship, as regards the number of para 2, respondent number 2 has filed this affidavit, Lordship.
Yes, however, as regards the number of employees, say the mill had a strength of so and so.
Out of whom 191 were working as
regular. How do you, from where do you make out that you are amongst the 191?
There's a list appended, my lord, where the list of employees are there, my lord. And we petitioners in both the matters fall within the 192, my lord.
Where is the list?
This is the list.
And
Page
only
number
8 casual
81.
workers, my lord.
No,
and
where is the list?
8 casual
This
workers
is
are not.
page number 81, Lordship.
That we have understood. How do you correlate this?
Lordship. And in the proposal also, they have mentioned that at regular employees 193, no, Lordship. Our name is shown in the 191 list, Lordship. Petition number 1 is CL number 91, Lordship. Rohini Sarkar. This is the petition number 1, Lordship.
No, see, Mr. Monta, this may be her brief, but I'm trying to just point it out to you. This page 70 is a part of the annexures.
Yes, yes.
This was an affidavit in some other case.
Same case, my the second round of litigation, earlier case.
Other case,
Other case, other case.
5203.
Yes, yes.
And so far as the averments in paragraph 2 in this affidavit is concerned, it is not connected with any annexure, further annexure.
Yes, yes.
And
I
they have
understand.
independently given this
Yes.
annexure at annexure 12.
Yes.
Separately.
Separate, yes.
How do you connect this?
Yes, I got it, my lordship. Just a moment.
Because this this annexure you have got under RTA, some RTA application.
Yes.
That list.
Yes. So, my lord, may I clarify, my lord?
Yes, yes.
So, my lord, it is not disputed by the respondents also that there were total 222 numbers of employees. my
No,
lord.
we are not on the numbers who are, we are only concerned whether your averment that you, in an earlier round of litigation, it is you only the petitioners who have been deemed to be regular employees.
Yes.
If that is not disputed, then matter will be different.
Yes.
But if it is only a kind of a thread which we are trying to connect.
Yes, yes. So, my lord, that can be ascertained from the fact, my lord, that the paragraph says, my lord, there are 8 numbers of casual employees only. 8 number of casual
Yes.
employees. And those 8 numbers of casual employees have been listed and it's their pleaded case, my lord. It is not their case that we are not included in those 192 or.
Yes, Mr. Bordole, what do you say?
If otherwise pursuant to the order passed in that particular writ petition, afterwards a hearing has been conducted before the authority, whereby the petitioners were called and a hearing was, they were heard at length, Your Lord. And they have failed to produce any order by which it can be shown that they have been regular. They have never been regularized.
Where is that
Because-
order? Where is that order?
It is in my affidavit in opposition, page number 67, annexure 8, Your Lord. No, there's a joint affidavit in opposition filed by the earlier pending counsel
In both the cases?
in both the cases.
But you filed in which one?
It will be
Can you cover both the
item number
cases?
22. If I'm not wrong.
Mohantas case.
Joint-
Perhaps
joint-
it's the same.
It's the same. Both the cases, joint affidavit has been filed.
Which page?
Page number 67, annexure 8. Your Lord.
My lord, peruses paragraph 3 and 4, my lord. The narration changes, my lord, in the second round of litigation. In the earlier round, they said 193 odd were regular. Now that has been changed.
But if you are given an opportunity pursuant to the order passed in the earlier petition, where they have come to a conclusion that you are not regular.
That has been
Wow, wow.
challenged, my
And
lord.
but Your Lord, after liquidation, they have been paid, Your Lord, and they have accepted the same.
Not all.
Not all.
Not all.
Mohantas
The
has-
remaining that I have the instruction that 17 numbers of petitioner are yet to receive TPR
In item number 20.
in item number 20 out of 40. And in fact, in respect of item number 23, the petitioners, they have accepted TPR.
And your prayer is not against the findings arrived that you are not regular.
Yes.
You have presumed that you are regular and you are therefore submitting that you should be given the benefit as a regular employee. We are not finding that order.
Lordship,
No, we have the records. Which writ petition I would take?
page 67. Your Lord.
Of which writ petition?
Lordship, this is a joint affidavit.
No, joint affidavit understood. In which there are two writ petitions, 3536 and 1423.
1423.
We take up 1423.
Lordship may take up 1423.
Yes. Affidavit starts at page 46. Can you give us the internal page?
Internal page 67, Your Lordship. Annexure 8. My
Okay. 67.
an order dated 15/11/2016, passed by the liquidator.
Annexure?
Annexer B, page 67. Oh, sorry, Annexer 8, your lordship, page
8.
8.
1511
1511 2016, the order passed by the deputy.
67. Yes, 1511.
Yes. If lordship, if I read it.
Yes, 15. Please read.
Peruse the order passed by the Honorable Guwahati High Court in WPC so and so dated so and so in the matter of payment of VRS to the employees of Assam Cooperative Spinning Mill Limited, Poitamari, Bongaigaon. Also peruse the petition received from so and others dated 8/9/2016 and from Srimati Janki Chakraborty, that is the petitioner in respect of item number 22, your lordship,
Yes.
and others dated 14/9/2016, the workers of Poitamari Spinning Mills Limited, Bongaigaon. On the matter, hearing took place on so and so, and perused such representations, consulted the records, and took personal hearing of such workers. Accordingly, the undersigned came to the following findings. Number 1, the workers failed to produce any official documents or records at the time of hearing to show that the management of the mill took a decision to regularize their service by allotting time scale to them. The workers also failed to produce any documents or record to establish that they have ever demanded regular scale of pay from the state government. Under the above situation, it is told that the floor level workers of the mills were workers and they were wage earners. Hence, the claim of the floor level workers of the mill to regular scale of pay is hereby dismissed. Also dismiss their claim that the benefits under the VRS have been extended to 15 non-employees of the mill. However, the dismissal will not prohibit the workers to approach the state government for it. So this is the order passed. And based on that, the CA firm has calculated the VRS dues and they have been paid upon liquidation.
I think better you take the amount. We close this. They are in distress, filed in 17, we are in 2024. 7 years have passed.
And regarding the
And if you go technically, then this order of 15/11/2016 needs to be challenged.
Yes,
And these writ petitions were filed thereafter, but
Yes.
not challenged.
it has not been.
It's not a subsequent development.
Mr. In item 22, we have challenge.
This
In my
15
matter, we have challenged.
15/11.
Yes.
15/11 challenged.
Wait for date of extraordinary.
Item of- They have paid to set aside and cause the communication dated so and so.
The 15/11 has been challenged. No, do you have any, what grounds are you basing your challenge 15/11? Do you have any orders of regularization which you had produced and not considered?
But that is not there. I was of the impression because I was not aware of the other writ petition. My learned friend had a better drafted petition, my lord.
No,
That
even
affidavit
even
was-
otherwise, since you are challenging 15/11,
No.
that means you need to obviously make out a case that those findings are perverse,
My lord.
or
That-
you had documents, but those are not been considered. Do you have any documents here?
There are no documents as such where there's a
They have annexed
Clear
the
order of
appointment
regulation.
letters, your lordship, but not the regularization.
No documents. Yes, madam, do you have any documents?
Yeah.
Huh?
regulation. order.
Any regulation order?
No, they have not issued, only they have issued quarter,
That has
lordship.
been done by the management, your lordship. The state government hardly has
Now,
any role.
much water has flown now.
But every
Mill
document
is
they show.
gone.
as
It's
well.
under liquidator. It's
Liquidation has been
liquidator
done
has
dated in 2010,
somehow
your
the
lordship.
calculation has been done by a CA firm. Amount has been calculated. I think you should take the amount. In your case, madam, have you taken,
Yes,
any of
they
you
have
have taken the amount? No.
They have taken the amount.
They have
And
taken the amount.
Amount you have
Petitioners,
taken.
they have taken the amount. VRS employees,
Actually, I am not even.
but in respect of item 22, I have instruction that 17 petitioners.
No, Mr. Mounta has said
17.
Out of 44, 17.
17 are yet to receive, and that amount is lying in the account. I have to instruct.
So if this amount is paid, my lord, just one request, my lord, which has been made by the petitioners, my lord.
Yes.
If it can be paid through account paid checks routed through the court, my lord, because they don't want to go and visit the cooperative department office, my lord, to get the payment, my lord. I don't know, for some reasons, my lord.
From the court, it is difficult.
Not from the court, account paid checks in a time. No. They have the funds, already funds are there. Lordship may kindly produce the instruction.
Where is the liquidator seated?
Have to.
Now, the amount would be paid by the liquidator's office, isn't
Yes,
it?
it will be paid by the liquid. I can get the instruction.
No, where is it? He is in Bongaigaon.
Place is online.
Okay. Where are you, Mr. Monto?
Different parts of the statement.
See, if they send it by post, registered post, something happens, then again you have to run around. Don't insist on that.
I've been told.
We'll make some observation that
Yes, Lordship may give a time.
If they visit the office, my lord, it's a bit difficult to.
no, we'll say before you go, we'll intimate and everything will be ready, will be paid to you. Both these two writ petitions being filed with an analogous cause of action are taken up for hearing together and are being disposed of by this common order. Full stop. While in WPC 1423, there are 45 numbers of petitioners, comma, in WPC 3536 of 2017, there are 13 numbers. Madam, 13 numbers.
Second petition, there are 13.
13 numbers of petitioners. Full stop. The petitioners were engaged as floor level worker trainee in the erstwhile Assam Cooperative Spinning Mill Limited at Boitamari, Boitamari. Oh, তুমি তো জানিবা Bongaigaon, in the district of Bongaigaon. The said mill had, however, gone on liquidation, and accordingly, the workers, including the petitioners, were placed under a voluntary retirement scheme. Full stop. It is the case of the petitioners that though the benefits under the scheme have been worked out, comma, since the petitioner claims to be regular employees, comma, they are entitled to a higher amount. Full stop. Accordingly, the petitioners have also put to challenge an order dated 15/11/2016 passed by the liquidator, as per which the petitioners have been held to be held not to be regular employees. Full stop. I have heard Sri P. Mahanta, learned counsel for the petitioners in WPC 1423 of 17, and Ms. A. Begum, learned counsel for the petitioners in WPC 3536 of 2017. Full stop. I have also heard Sri G. Borderline, learned standing counsel, Cooperation Department. Full stop. Para. At the outset, comma, Sri Mahanta, the learned counsel, has submitted that so far as his petition is concerned, comma, there are 45 petitioners, and except 17, the others have accepted the amount worked out by the liquidator who had engaged a CA firm to make the calculations. Full stop. Sri Mohanta, however, transpires that from the records available, including the records of WPC 3536 2017, it appears that in an earlier writ proceeding, there is an admission that the petitioners were deemed to be regular employees. Full stop. In this connection, the attention of this court has been drawn to an affidavit in opposition filed in a previous writ petition, namely WPC 5203 of 2011, which was instituted by the union, by the employees union of the mill in question. Full stop. It is accordingly submitted that the petitioners are entitled to the amounts as as regular employees and not as per the rate worked out. Full stop. Sri Bordeloi, the learned counsel for the department, has however submitted that in the earlier round of litigation instituted by the union, that is WPC 5203 of 2011, the matter was directed to be considered, and accordingly, the liquidator had conducted an inquiry giving personal hearing to the petitioners. Full stop. In the said hearing, no documents whatsoever could be produced by the petitioners towards their claim of regularization. No, towards their claim that they were regular employees. Full stop. Since the aforesaid communication, accordingly, communication dated 15/11/2016 was issued. Full stop. Since the said communication is a subject matter of challenge, this court had inquired from the learned counsel for the petitioners regarding the availability of any materials or documents to substantiate their claim that they were regular employees. However, from the records available, there is no materials to come to a conclusion that the petitioners were regular employees of the mill in question, except from the statement made in the affidavit filed by the co-person department in WPC 5203 of 2011. Full stop. Since a verification exercise was made in which it has been reflected that no materials was able to be produced by the petitioners to substantiate their claim, and even in this proceeding, there are no documents towards substantiation of the said claim, the aspect this court is of the considered opinion that the challenge to the order dated 15/11/2016 cannot be countenanced. Para. As transferred, comma, the entitlements of the petitioners have already been worked out, and so far as WPC 1423 is concerned, comma, only 17 of the petitioners are to be paid. Full stop. The petitioner, however, this court has, however, been informed that the petitioners in WPC 3536 of 2017 have not received.
They have received it.
Madam,
Madam,
they have received.
as per my instruction,
Oh.
they have received.
Is it? Sri Bordoloi, the Learned Standing Council, Cooperation Department has submitted that all the 13 petitioners in WPC 3536 have received the
VRS.
the benefits under the VRS. Full stop, para. In view of the aforesaid facts and circumstances, comma, both the writ petitions are disposed of by under facts and circumstances. This court is your opinion that no effective relief can be granted to the petitioners in these cases, and accordingly, the writ petitions are dismissed. Full stop. It is, however, made clear. It is, however, directed that so far as the 17 numbers of petitioners in WPC 1423 who are yet to receive the benefits under the VRS are concerned, comma, the same be released to them within a period of 45 days from the date of receipt of certified copy of this order. Are your addresses known to the liquidator?
Not aware.
No, so far as considering your subsequent prayer is concerned, that account pay check, unless
We'll furnish the addresses if required. Furnish the address,
to whom?
the liquidator, and
By
otherwise
whom?
we can. we won't
Tell
do
us the modality, we can work it out if there is a modality.
Otherwise, my lord, if it is convenient, my lord, we'll deposit in the High Court. The petitioners come in with their identity cards and collect.
No, not burden the risk. The petitioners, 45 days, the Learned Standing Council of the department. But are you appearing for the liquidator? You aren't. You're not appearing for the liquidator.
No, yeah.
How can you have control?
Fund is
Liquidator
lying
is
with
a
the department.
liquidator is a party.
Liquidator is
It's a party. Yeah.
but the fund is lying with the department, my lord.
Otherwise, your lordship, the latest instruction which I have received from the Assistant Registrar of Cooperative Societies, the liquidator office is still at Boitamari, Bongaigaon. The
Okay.
signature shows that yours faithfully liquidated Assam Cooperative Spinning Mill, Boitamari, Bongaigaon.
You tell us how, from where do you want to collect? You will have to collect it from the liquidator.
Yes, sir. Because fund has already been released from the government department, and it will be with the liquidator.
It's a time frame already.
45 days. Now, we wanted to incorporate something that you'll incorporate, they'll intimate your a week before you go, and thereafter.
Yes. The addresses are known to the liquidator, my lord, because he had been there with the entire.
Is the liquidator represented? Are you representing the liquidator?
Otherwise, your lordship, he is a.
Okay, to facilitate the release, comma, Sri Bordoloi, the Learned Standing Council, would instruct the department
Yes, sir. I can communicate.
to make communication with the liquidator,
No, that's it.
so that the order can be, order for release can be complied with without any complied with in a smooth manner.
My lord, may reproduce the chart, my lord, the easier, my lord, the chart of the last stage of the entitlement. my lord.
That is already there,
This you already with us.
already there.
My learned friend is taken.
Okay. All side right, huh?
Deeply available.
Okay.
Available.
Okay, rest matters, I will give dates. No time. Mr. Sakya, you're waiting for a long which matter? Which one? Which one? Which one? Hearing matter.
26 matter.
What is the matter about?
That bank officer was imposed punishment and the punishment for recovery of money he had given the recovery of money. Money was given. Then he was reinstated in service. But the next managing director came and held that the earlier order of the MD was wrong. And so he did not want to release the area salary. Suspension period salary, the next managing director held that the suspension period area salary he will not get. He has
Who
given
they are appearing, Mr. Goswami? Yes, which bank? Apex Bank?
Apex Bank.
No, today we'll not have the time,
Yes,
but
Lord.
we'll have it very soon.
Lord.
Matter of which year?
Lordship, 2021.
You're in service, still in service,
No, I'm returned.
retired. How much, what was the suspension period?
Under the area salary for 5 years.
5 years.
So Lordship,
That has been the earlier managing director by the board of directors held that since the 4 or 5 employees, while they disburse the money to the agents, could not collect the money, they should pay. They have paid. And I am one of them. I have paid, entire 5 lakh, 6 lakh rupees, they have got recovery. And then I was reinstated with full salary. But subsequently, the new
Did
managing
you
director,
initiate a proceeding against him?
yes, Lordship. Proceeding,
Proceeding was dropped.
no, yes, the proceeding was drawn, and accordingly, after inquiry report, Lordship, it was placed before the board of directors meeting. According to the decision of the BOD, Lordship, the managing director throw out or pass an order for
Okay,
punishment.
we'll have a date.
Yes, Lordship,
We'll give a date of your convenience. Please tell our court master.
Small.
Okay.